All rise.
Kosovo Specialist Chambers is now in session.
Please be seated. Good morning. Court officer, can you please call the case?
Good morning, Your Honors. This is case KSC BC 2020-05, the Specialist Prosecutor versus Salih Mustafa.
Thank you. First of all, I will call appearances. Let me see for who's present for the Specialist Prosecutor's Office. You have the floor.
Good morning, Your Honors, and everyone in and around the courtroom. The SPO is represented today by Mr. Jack Smith, the Specialist Prosecutor, Prosecutors Silvia Dascoli and Prosecutor Filippo De Minicis, our case manager Julie Mann. We also have two SPO legal interns with us, Ebba Nermark and Benjamin Dearden. And I'm Cezary Michalczuk, the SPO Prosecutor.
Thank you. Victims' Counsel, you have the floor.
Good morning, Your Honors. Good morning, everybody. The victims participating in this trial are today represented by a new addition to the team, Jack Proven as Junior Legal Associate, Brescia Vossenberg as Co-Counsel, and by myself, Annie Poes as Counsel.
Thank you. Defense Counsel, you have the floor.
Good morning, Your Honor. My name is Julius von Bonnet. The defense is represented by myself, Julius von Bonnet, my co-counsel, Mr. Betim Shala, interpreter and investigator, Mr. Fatmir Pelay, and joining us via remote is Mr. Salih Mustafa. Thank you very much.
Thank you. And for the record, you are appearing before trial panel 1. Today we begin with the hearing of the closing statements in this case, and we will follow the agenda as set out in the decision, setting the agenda for the closing statements and related matters, which is filing 468. I remind you that this hearing is held in open session unless otherwise requested by the parties or the Victims' Counsel or decided by the panel. And because in the course of the closing statements, reference may be made to confidential information or information subjected to protective measures, I remind you to give me prior notice should you wish to go into closed or private session for the purpose of your submissions. And I also remind you that we will follow the procedure on requesting in-court redactions that we have been using throughout the trial and as set out in the conduct of proceedings, in which is filing 170. We can now begin with the closing statements of the SPO, for which you were allocated 5.5 hours as requested. Please inform us, like always, of any changes time-wise for planning purposes. You have the floor.
Your Honors, Counsel, good morning. As Specialist Prosecutor, I am pleased to have the privilege of addressing you today as we conclude the second trial of this court. If it is to have meaning, the work of this court must focus on victims. Victims must know that this is a place that they can tell their story without fear, that accountability has no expiration date, and that the rule of law matters. So as I begin my remarks to you today, I will ask that we take a moment to think about one of the victims in this case, the victim who did not survive the torture at this last detention compound, the victim whose family you heard from during the course of this trial, the victim whose murder is charged in this case. How old would he be today? And what would he have done with his life if it had not been taken from him? He'd be in his early 50s now, we know that. But what would he have done with his life? We will never know for sure. He'd have lived a life, we can say that much. Maybe a really good life, maybe a tough life, maybe a very successful life, or maybe not. Maybe he would have contributed tremendously to his community and even to his country. Maybe he would have had a family of his own, children of his own, to raise to adulthood. Maybe, possibly. We can only speculate on what he would have done with his time on earth up to today and beyond. The truth is we will never know, and his family will never know, because of Salih Mustafa and the men under his command who tortured and killed him. We will never know. Your Honors, the victims and their personal tragedies are at the very heart of this case. For the first time, after more than 23 years, this case has given them voice and has given them an opportunity to speak of the pain and suffering they were forced to endure in April of 1999, and also how the long shadow of those traumatic events still haunts them. In the words of witness 1679, a victim detained and tortured for 18 days by Mr. Mustafa and his men. I feel like I'm just watching a movie. When I go to bed at night, I wake up during the night, I scream. I say things in my sleep. My family tell me that. So I wake up and scream and I get sweaty. I remember the voices of the people. I have all those flashbacks. The voices of the victims and the voices of the people who tortured us. This case is also about the social stigma that the victims, all Kosovar Albanians, had to endure for years after these traumatic events. In the words of another victim, I hope one day we will all be free to speak out about what we've lived through. I hope for a future free from crime, murder, and fear. All I'm asking for is freedom. We love our country, Kosovo, and it has never been our intention to say anything bad about it. All I'm asking is to be free to speak out about what we went through without any fear. I hope that one day we will be able to. Your Honors, before the existence of this court, this tribunal, the Kosovo Specialist Chambers, that freedom to speak out about what the victims went through simply did not exist. And even today, it requires extraordinary courage. When two of the victims in this case saw each other, years after the events in Zlash, one asked the other if he would tell what had happened to them at Zlash. And he was told it was not the right time, not the right place, because, and I quote, if you're going to report what happened, all the institutions are held by those people. Your Honors, the permanent stigma caused by the accused's actions and those acting upon his orders and under his leadership and control, who labeled the victims as spies and collaborators of the enemy. A label falsely attributed to them because they were either perceived as not sufficiently loyal to the KLA or accused of displaying the wrong political affiliations. Maybe they favored the LDK over the KLA to run the country going forward. Maybe they thought Ibrahim Rugova, instead of Hashim Thaçi, was the person best suited to lead Kosovo once it achieved independence. And for this, Your Honors, for this they were imprisoned at an isolated compound. They were beaten daily. For this they were tortured and in one case killed. These people were not spies. They were not working with the enemy. They were not enemies of Kosovo. It's important to note that this trial began a year ago, and in that year, this court has not heard a scintilla of evidence from any corner that would support those baseless allegations. So who were these victims? They were fellow Kosovar Albanians, community members, countrymen, some of whom volunteered for service with the KLA because they believed strongly in Kosovo's fight for independence. The fact that each and every victim in this case was a fellow Kosovar Albanian does not fit the narrative of the enemies of this court. For those who've been opponents of this court, sought to obstruct the work of this court and my office at every turn, this is an inconvenient fact, but it remains an unassailable fact. It is a fact you will never hear addressed by those who seek to destroy this institution of justice. They very consciously do not address such victims because they cannot. Because to do so would put the lie to their worldview about what this court is and who it's for. This is a Kosovo court created by the will of the Kosovo people, and it serves all victims under its mandate. And that includes many Kosovar citizens. The truth, as this court heard over the last year, is that certain KLA leaders, like Mr. Mustafa, used their power to victimize and brutalize fellow Kosovars, including individuals whose only transgressions were to have been judged insufficiently loyal to the KLA and its leaders, or to possess political views that differed from the KLA leaders. As you saw in the course of the evidence presented over this last year, there was no legitimate military objective for their detention, no justification whatsoever for the deplorable conditions under which they were held, or for the manner in which they were tortured during detention. Any discussion of this case must begin with a full reckoning of the gravity of the crimes involved and the remarkable level of violence which these victims were subjected. When considering this evidence, Your Honors, it's critically important never to forget that everything the victims underwent, everything they suffered through, is attributable to the accused because he not only permitted it, he not only aided it, he not only supported it, Your Honors, he personally modeled violence for his subordinates. At the last detention compound, detainees were beaten daily. Detainees imprisoned in the stable could hear inhuman screams of those being beaten upstairs. Witness 1679 explained, "I could hear all sorts of voices, and it's there where I learned that somebody's voice can change because of what he's undergoing." Witness 1679 heard people screaming, howling like dogs, making sounds like cats, screaming cats because of the torture and the pain. Similarly, witness 3593 testified regarding the sounds of people being beaten and their screams, adding that we simply couldn't sleep because we were scared that at any time they would come down and bring us upstairs as well. Witness 3593 further testified that when hearing voices and the screams of the people being beaten, we felt very badly because we were thinking about ourselves. We were thinking we would have the same chance as them. Witness 1679 made this chillingly clear when he told us, "You were just waiting for death when it will come. Today, tomorrow, you were waiting for you to be killed." This last detention compound was nothing less than a torture chamber for these people. And in the course of the evidence, you heard repeated instances of that torture. The witnesses in this case saw each other covered in blood and bruises, having been beaten until they lost consciousness. They were beaten with hatchets and iron police batons, their flesh burned with candles and hot irons. They were stabbed with knives. They were even electrocuted. Witness 1679 described how his tormentors would sit him down in a chair, light a candle, put it near his back so the drops would fall on his skin and burn him. They also used an electricity box to torture him. They would fold up his trousers, attach wires to the flesh on both his legs and his feet, and turn the box on. The electric shock would make his body shake. As the forensic reports offered by Victims' Counsel makes clear, this torture left permanent and unmistakable scars on the bodies and the minds of those who survived it. The grave nature of this violence goes not only to what is a just sentence in this case, Your Honors, but also to the credibility of the victims in this case, particularly those who had the courage to identify the accused for his role in these offenses. As you will hear throughout our presentation today, these victims are corroborated in their accounts in nearly all ways reasonably possible after 20-plus years, and they have no incentive to falsely identify the accused as being involved in or responsible for their torment. Given the truly incredible degree of suffering they went through, the many years they have waited to be heard, their only incentive is to correctly identify those involved in the hope that justice is served. Of all the abuse heaped upon the victims, nobody suffered more than the young man whose murder is charged in this case. In describing his condition, witness 1679 stated, "It was a catastrophe. His body had all these marks. It was terrible. Every one of us was beaten, but he was beaten the most." So what do we know about the events leading to the death of this young man? And how does what we know show, beyond any reasonable doubt, that Mr. Mustafa is responsible for his murder? Well, let's begin with the basics. We know that the murder victim was brought to this last detention compound on April 1st of 1999. We further know that that compound at that time was controlled by the BIA unit of the Kosovo Liberation Army. We also know that BIA and that compound were under the command of the accused in this case, Mr. Salih Mustafa. We further know that on April 1st, the accused was there at the compound to witness the murder victim being handed over to a guard, Mohammed Ayadi, at the gate of the compound. We further know that Ayadi himself was a BIA soldier under the command of the accused. We know that this victim was tortured at this last detention compound over the course of more than 2 weeks, starting on that day, April 1st. And very importantly, we know that this last detention compound was a very small, very isolated compound. And we know in the same period, at that very small, very isolated compound, the accused, by his own admission and other evidence, was there at that very same compound at that very same time. We know that from day one, this particular victim, the murder victim, was singled out for particularly abusive treatment. A decision was made from the beginning to beat him more severely and treat him more harshly. Witness 4669 saw 5 or 6 people beat him with everything they had in their hands. Witness 1679 told us how he saw that he was burnt with an iron and stabbed with a knife. The murder victim was also the only prisoner who was restrained and had his hands tied at all times. Significantly, witness 1679 told us that this victim knew many of his captors, including Salih, the accused, Tabut, Ilmavella, and Fatmir, and as such, quote, they were afraid to remove his handcuffs. When he was brought back to the barn after being tortured, he looked destroyed from the beatings. He had bruises and marks on his face and body, and he could not stand up because of his injuries. According to witness 4669, he was, quote, black from the beatings, everything on his face, his eyes, nose, everything was black. He was bruised black on all visible parts of his body. He could barely open his eyes. The captors even used the murder victim to terrorize other prisoners, displaying his severely beaten body as a warning. Witness 4669 stated that when the victim was brought to the stable, badly mistreated, all the prisoners were in fear, as they understood the situation was critical and that the same could happen to them. Every time he was brought to the barn, witness 4669 and his co-detainees were forced to say, death to the traitors, death to the thieves, death to the thugs, and glory to the KLA. What else do we know? We know that as a result of these severe beatings, the murder victim was already on the verge of death when the other prisoners last saw him. When witness 4669 last saw the victim, he was, quote, almost dead, and was lying down, was even more swollen. His nose was bleeding, he was unable to speak, and was just crying out of pain. He was so close to death at this point that the soldiers, according to witness 4669, had to hold him, all the weight of his body. They placed him lying on the ground because he could not stand on his feet. In the words of witness 1679, you cannot even describe his state in words, his body, his injuries. The smell of flesh that we could sense, it was terrible. In my opinion, it was a massacre. Although the murder victim may still have been breathing when last seen by other prisoners, his life was over. All visible parts of his body black with bruises, not able to speak, and barely able to open his eyes. He could not walk on his own. He was almost dead. And, Your Honors, when they chose not to release him, they condemned him to death. We know that the soldiers who tortured and brutalized this victim were BIA soldiers under the command of the accused, and that no other commander had the ability to exercise control over these soldiers. It was the accused alone who had the power to give them orders, had the power to discipline them. What else do we know? We know that when the other prisoners were released, the murder victim, along with another prisoner, were intentionally held back. Again, the murder victim was singled out. They did not allow the other prisoners to bring this victim with them, along with them to safety. They did not allow the other prisoners to bring him to safety despite his grievous condition. The only reasonable inference to draw is his captors had decided he would not survive. He would not be allowed to live. His last chance to survive was the moment when the other prisoners were released. When the captors held him back, they sealed his fate. And they ensured that he would never see his family again. There is more we know. We know that when the other prisoners were released, it was as the Serbian offensive was approaching the area of Zlash. We further know that the accused himself was present at the Zlash detention compound at that very time. A defense witness, Tutra Hadri, specifically recalled seeing the accused at the Zlash detention compound at this very time. As a result, we know the accused was present at the Slash detention compound at two key moments related to this crime. April 1st, the day the victim was delivered to the compound, and as the Serbian offensive approached and the decision was made not to release this victim along with other prisoners. We further know that it was known within the KLAs just a few days after the release of other prisoners that the murder victim was dead. As witness 4600 told you, he learned directly from a KLA commander that the murder victim was dead within days of the offensive that had necessitated the KLA's retreat from Slash and the release of the other prisoners. Finally, we know that the murder victim's body was found in early July, secreted in a shallow grave very near the isolated Slash detention compound. He was barefoot and his legs had been broken, consistent with the testimony of witness 1679, who stated that when he last saw him, he could not walk on his own. While today the accused would like to blame advancing Serb forces for his death, the evidence in this case does not support such a defense. As an initial matter, while Serbian forces may have entered the area generally, there is no reliable evidence in this case that those forces entered the Slash detention compound where the victim, who could not walk on his own, was last seen. Moreover, we know the accused and his subordinates had a choice whether to release the prisoner, as they did release other prisoners. Knowing his condition, knowing the approach of Serbian forces, they affirmatively chose not to do so. They released other prisoners but made the very intentional choice not to release him, the person they had beaten most severely and who knew his captors by name from his time, before his time in detention. Given the impending approach of Serbian forces and his grave, immobile condition, we know the only reason to do so was they never intended for him to be released. Unlike other prisoners who only learned of the accused and his subordinates in the course of their imprisonment, the murder victim knew the accused, knew him as Salih, and knew his subordinates as well. Everything we know adds up to just one conclusion. The accused knew the murder victim had been arrested. This particular victim was singled out from the beginning for more severe treatment. He was tortured from the day of his arrival in unimaginable ways until he could not stand or walk or even open his eyes, until his flesh, black with bruises, smelled of decay and death. In that condition, he was held back while others were released. And then shortly thereafter, his body was found just next to the isolated Slash detention compound, the place where he had been tortured. Well, the SPO has not called a witness who was present when the murder victim drew his last breath. That cannot be a prerequisite to a finding of guilt. The accused and those under his command committed this crime so there'd be as few witnesses as possible, torturing the victim at a remote location and then releasing other victims who could be witnesses to his final moments. Salih Mustafa, commander of BIA, was there at the Slash detention compound the very day this victim was delivered into his custody, delivered to a place that he would never leave. Salih Mustafa, as the commander of BIA, was there at the Slash detention compound the very time the fateful decision was made not to release this victim along with other prisoners, despite the impending approach of Serbian forces. The accused is criminally responsible for his murder, and the facts leave no room for reasonable doubt under each of the theories of liability charged in this case. There are other victims in this case who survived their time in Slash, but only as broken men. Some sat in a chair in this courtroom, told you what they suffered, told you about their enduring pain, their nightmares. Our trial team will talk about their evidence in more detail, about what was proven in this case, about the responsibility of the accused. But for a moment, I would like to talk to you about the tremendous courage these people showed to come here to testify. They did so in a climate of fear and intimidation that persists in Kosovo to this day. It's part of the reason this court was created, and certainly why this courtroom is located here in The Hague. When considering the evidence of these victims, when weighing their testimony and weighing their credibility, please keep in mind these circumstances. Keep in mind how hard it was for these victims to come here and tell you their stories. And we saw it in this case, the intimidation that persists in Kosovo to this day. This was afraid, very afraid to be a witness against a KLA commander like the accused. He attempted to recant previous statements. He attempted to minimize the serious injuries he saw to other prisoners. He even withdrew from proceedings as a participating victim. Significantly, this same witness, witness 3594, admitted in a prior interview statement that he had been, quote, sent word to be careful, not to mention any names. And at trial, Your Honors, he did just that. I say all this to you because the witnesses who came before this chamber to tell their stories live in this climate of intimidation and retaliation every day. They are subject to it, and their families are subject to it. I dearly hope that the work of this tribunal and that the truths that it exposes through evidence and law over time help eradicate this climate that has been the scourge of rule of law efforts in Kosovo for 2 decades now. In the meantime, in your deliberations on this case, Your Honors will be required to consider how this climate has affected individual witnesses. Now, throughout this case, throughout the defense case, we saw numerous Facebook posts from supporters of the accused. Those posts described how proud they were of him, to the point of creating T-shirts to show their support for him. Sadly, you will find no public statements of support for the victims of his crimes. They stand nothing to gain by naming him as their tormentor, only to be named as pariahs by those who cling to this false concept of an entirely clean war where the Serbian forces commit atrocities, but the KLA not a single crime. Your Honors, we ask that the court take this reality into account in assessing the credibility of the witnesses in this case, particularly those witnesses like 1679, 4600, and 3593, whose testimony directly implicates the accused, a senior KLA commander, and the crimes you've heard about. Given the climate of retaliation that they live in and that their families live in, they had every reason not to say his name, knowing what doing so could mean for them and their families. They had absolutely zero reason to identify him, to say what he did, if he were not there, if he were not in charge, and if he were not participating and overseeing their torture. The raw courage these witnesses had to exhibit to come forward, and all they have stood to lose by doing so, weighs very strongly in favor of their credibility. When our trial team goes through the evidence of these witnesses in more detail, you'll also hear how their evidence was repeatedly corroborated over and over again during the course of a year of trial. From the accused's admissions regarding his presence at Slash, to his admissions regarding his role as the unquestioned leader of BIA, the victims' stories were corroborated by the accused himself in ways they could never have imagined when they gave their initial statements. Similarly, the victim's ability to name actual BIA soldiers involved in their torture, whose presence at Slash was confirmed by completely unrelated witnesses and other evidence, provides telling corroboration. As does the prisoner list and the forensic reports submitted by victims' counsel, both of which the victims could never have known would exist when they gave their statements implicating the accused. This case is and must be about the victims, but ultimately it is also, of course, about the accused and his conduct. The evidence that proves his responsibility for the crimes charged is compelling and layered, and it will be presented over the course of today in detail by our team. What is notable is the commanding role of the accused over BIA and the Slash detention compound. He was not an absent or disengaged commander. As he explained himself when asked about the headquarters of BIA during his interview with the SPO, he stated unequivocally, and I quote, "I am the headquarters," underlying his complete and ultimate authority over his subordinates in BIA. He was a commanding figure in BIA in all respects. He gave orders, and those orders were followed. The first time witness 1679 was beaten, the very first time, it was in the presence of the accused who initiated, who began, who started the assault. And then after the accused subordinates joined in, he directed his subordinates to finish him. The soldiers obeyed and continued to punch, kick, and beat witness 1679 until he lost consciousness. In his commanding role, he modeled criminal brutality to his subordinates, directly participating in barbaric beatings of prisoners, giving them license and direction to do the same. By committing serious acts of violence in front of his subordinates, he communicated in a way that words cannot, that he approved, that he condoned, and that he expected them to behave similarly. This brings me to the issue of sentencing. My office has requested that you impose a lengthy term of imprisonment of the accused in this case. And you should know that we do not do so lightly, but only after a thorough consideration of all the relevant factors that can legitimately be considered in determining the just sentence in such a serious case. The gravity and depravity of the charged crimes, including the tremendous effect they've had on the lives of the victims in this case, is a particularly weighty consideration. In this case, the accused's dual role as commander and participant constitutes a particularly aggravating factor for sentencing. As a direct perpetrator, Salih Mustafa ensured that those under his command treated the victims with particular brutality. Conversely, the lack of any mitigating factors of any weight is especially striking in this case. Independent of defending himself against the charges he faced, the accused has never once made any effort to express remorse or sympathy for the victims of the crimes you've heard of over the last year. Despite hearing how the murder victim was beaten until his skin was black with bruises, despite hearing how witness 1679 was electrocuted, how victims were stigmatized in their communities for decades, how they suffered physically and psychologically to this day, never once did he offer a hint of remorse or even an acknowledgement of the damage that had been caused. Coupled with the weighty, aggravating factors, this lack of mitigation weighs strongly in favor of the sentence we've recommended. This case is about the victims and their families, innocent persons who suffered a lifetime of pain because of the accused. This case is also about accountability and affirming the rule of law for the future in Kosovo. Future built on justice that the victims and their families have sought for so long, and on their freedom to live as equal members of the Kosovar community. Your Honors, for these reasons, and based solely on the evidence in the law, we ask that you find the accused guilty of each of the crimes charged and impose the sentence recommended, as it is a just and fitting one for crimes so heinous and so grave. Thank you very much for your time this morning. I will now turn the floor over to my colleagues who will continue our presentation and provide additional details of our arguments. Thank you again.
Prosecutor, I will now give the floor to one of your colleagues.
Good morning, Your Honors, and everyone in and around the courtroom. As the specialist prosecutor has already outlined, you had the opportunity to hear throughout the trial the voices of the victims, witnesses, who courageously came forward to testify in this case about what they experienced in Slush in April 1999. After more than 23 years, this trial has given them an opportunity to speak, to have their voices heard. And what have they helped us establish? What have they told us? One message should be clear from the outset. The evidence presented at trial proves that the accused, Mr. Salih Mustafa, is responsible beyond reasonable doubt for all of the crimes charged in the 4 counts of the indictment. The crimes of arbitrary detention, cruel treatment, torture, and murder. In this first part of the SPO closing statements, the Specialist Prosecutor's Office, SPO for brevity, will outline what the prosecution case is about and analyze in which ways the evidence of the victims' witnesses is corroborated. After the break, we will continue with discussing further elements of credibility and corroboration of the evidence, including those concerning the responsibility of the accused. We will then move on to assess the defense case, and the concluding part of the SPO statements will focus on sentencing. Your Honors, let me return to September 2021, when the SPO opened this case in this very courtroom. In its opening speech, the SPO underlined the relative simplicity and straightforwardness of the fact of the case to be presented. Throughout the trial, you heard the victims, witnesses, who, in simple and compelling terms, told you how, during the war in Kosovo, between approximately 1 and 19 April 1999, they were taken to the village of Slash and were unlawfully held in a compound in harsh, deplorable conditions, unfit for humans. You heard them describe how they were repeatedly abused, threatened, severely beaten or tortured by their captors. Their stories were straightforward. Their stories were strong, were similar to one another, and corroborating of one another. Their stories, Your Honors, established all of the elements of the crimes charged in the indictment and the responsibility of the accused, Mr. Salih Mustafa, for those crimes. Before moving to their stories, to their evidence, let me briefly describe the location where the charged crimes were perpetrated. The location matters greatly in this case. The SPO has referred to the detention place where the victims were held as the Slash detention compound. We are all familiar in this courtroom with its location, structure, as these were amply discussed at trial. So for the benefit of the public, however, I would like to show a few slides for us to visualize where the crimes charged in the indictment took place in April 1999. The crimes occurred in Slash, as we know, a small, remote village located in the mountainous region of Golak, east of Pristina, the capital of Kosovo. The map now displayed on the screens depicts the location of Slash in relation to Pristina. You can see Slash on the right-hand side. It is circled in blue. It is about 20 kilometers by road from Pristina. In April 1999, the village of Slash consisted of a few clusters of houses scattered over a wider hilly area, being connected to the main roads only via a small winding way. This is shown in the aerial photograph now displayed on the screen. You can see the group of houses in the middle of the photo. They're circled in blue. They represent the Slash detention compound. You can see how isolated it was. You can see how small it was. Surrounded only by trees, far away from inhabited places. Who ran this compound in April 1999? The compound was run by members of the Kosovo Liberation Army, in particular by a KLA group called BIA, B-I-A, which was commanded by the accused, Mr. Salih Mustafa. He was also known as Commander Salih, or simply Salih. As we heard at trial, the compound, which the SPO has called the Slash detention compound, was known in the area as the Skifterat base, or compound. The BIA unit, commanded by the accused, was in fact also known as Skifterat. BIA used that location as one of its bases. Salih Mustafa, as the BIA commander, was in charge and in control of the compound and of his BIA soldiers operating there. Now, a few buildings of this compound are particularly relevant for this case, as they were used by Salih Mustafa and other BIA members to detain, interrogate, and mistreat at least 7 local Kosovo Albanian civilians during the time frame of the charges. Your Honors, the relevant buildings now appear on the screens. I will return to these buildings in a moment. Let me now discuss, although in brief, what the evidence presented at trial established in relation to the 4 counts charged in the indictment. The details of the witness evidence of the victims, those who survived the mistreatment and torture in Slash, are provided in the prosecution final trial brief. So I will only give an outline of the established facts. First, who were the victims of the crimes in this case? As the specialist prosecutor said already, the victims were all local Kosovo Albanian civilians. None of them was taking active part in the hostilities at the time they were arrested, mistreated, or, for one of the detainees, killed. None of them posed any military threat to the KLA. None of them assisted the Serbian forces in any ways. What happened to those victims? They were arrested or abducted, taken to the village of Slash and detained. No arrest documents were provided to them. The victims were not told why they were arrested and then kept in detention, aside from some baseless accusations made during the interrogations that they were thieves, spies, Serbian collaborators. No evidence was presented at trial that they were spies, collaborators, none. Where specifically were the victims taken in Slash? They were all taken to the Slash detention compound and, specifically within it, to a set of buildings that the victims all consistently and independently recognized in photos shown to them during their in-court testimonies. The victims described being held in a cowshed, stable, or place used to keep animals, in their words, as well as in the basement of the building where they were taken for interrogation and beatings in the upper floor. Your Honors, the relevant buildings will now be shown on the screen. Most of the victims, including the murder victim, were detained in what we see on the screen as marked, the building marked as 4A. This building is now in focus on the screens. As well as in the basement of the building attached to it, which in the photo is marked with a red circle. This building is also zoomed in on the screens right now. They were also frequently mistreated in both of these places, 4A and the basement of the building now on the screens. On the upper floor of the building, still on the screens, the entrance to which you can see marked in red with a vertical line in the zoomed-in part, detainees were interrogated and tortured. Witness 4669 was detained in a separate building marked with number 5. Your Honors can see the zoomed-in part of this building on the screen. A few words about the photo now on the screens. Your Honors will remember that this is a photo that was marked in court by defense witness Selatin Krasniqi. a BIA member himself. He was the nephew of Adem Krasniqi, the owner of the slash detention compound, who had let the KLA use it as a contribution to the war effort. Mr. Selahattin Krasniqi knew the slash detention compound well and described it to the court, however, omitting what really happened in those buildings. The evidence presented by the SPO established beyond reasonable doubt that the victims were held in those buildings at the slash detention compound, some for a few days or a week, some others for about 2 weeks, some others for up to 18 or 19 days. During their detention, the victims were beaten, mistreated, and tortured almost every day, both in the barn, which was building 4A, and in the interrogation room, the upstairs part we just saw. In the barn, mistreatment took place in front of the other detainees, and this also instilled fear in all of them. Detainees were also taken, as we said, in the building upstairs, where they were interrogated, beaten, tortured. This upstairs part, and again we see it now zoomed in the screen, was accessible through the door indicated with the vertical line that I have mentioned. When detainees were taken upstairs through that door, they were taken there individually, one at a time. They were interrogated there, and they were brutally beaten, mistreated, or tortured, as we have heard during trial. At the slash detention compound, detainees were also psychologically abused. This, for example, included the soldiers entering the barn and displaying to the other detainees the severely injured body of one detainee in particular, the victim who was later murdered. At the slash detention compound, the conditions of detention were deplorable, inhumane. The victims were made to sleep on the floor in the animal barn, were given insufficient food and water, were kept in extremely unsanitary conditions. No medical care was offered to mend the wounds inflicted by the accused and his subordinates during the frequent interrogation and beating sessions. No family contacts or visits were allowed. And what role did Mr. Salih Mustafa have in all of that? The evidence established that he himself took part in and oversaw the mistreatments at the slash detention compound. 2 witnesses in particular, 1679 and 3593, named the accused as directly participating in their interrogation and beatings. Let's first recall the evidence of witness W01679. This witness, after being taken to the slash detention compound by BIA soldiers, was interrogated by Commander Salih, that is, the accused, Mr. Salih Mustafa. Commander Salih accused him of being a liar, shouted at him, cursed him, and then slapped him and beat him before leaving him to the hands of his BIA soldiers, who beat 1679 until he lost consciousness. The accused also took part in the beatings and mistreatment of witness W03593. This happened soon after the witness was taken to the slash detention compound and put in the barn. Shortly after that, he was dragged out of the barn by 3 to 4 people, taken to another building, and there he was severely beaten up. He was kicked, hit with wood, injured on his head and teeth, and he fainted at least a couple of times during those beatings. Those people were swearing at him and accusing him of being a collaborator of the Serbs. The beating, which lasted for a long time, ended when a man with a red hat, who was present during those beatings and whom the witness identified as the accused, took a revolver, put it to the witness' head, and pulled the trigger. The gun clicked but did not fire, and that man, the accused, said, "Let him be, he is lucky." The accused then interrogated the witness, 3593, about a week later. The time, the accused, again identified by this recognizable red hat, asked 3593 questions about thieves, and then beat him with a baseball bat. Further, the evidence established that the accused was at the slash detention compound when the victim, who was later murdered, was taken there. Surviving witnesses 1679, 3519, 4669 provided compelling evidence concerning the circumstances that ultimately led to this victim's murder. They testified about his extremely brutal and prolonged mistreatment, that he was kept behind and not freed when the other detainees were released in the wake of the Serbian offensive on or about 19 April 1999. Witnesses W01679 and W04669 also testified that the last time they saw the murder victim, he was in a terrible, near to death physical condition. The body of these victims were later found in a shallow grave in the immediate vicinity of the slash detention compound. My colleague, Mr. Dominicis, will address count 4, murder, in more details in his presentation later today. On its own, Your Honors, the evidence of the victims establishes all of the elements of the crimes charged in the indictment beyond a reasonable doubt. And this evidence is powerfully corroborated. I want to discuss today the corroboration coming in particular from the accused himself, from the victims, to the extent that they corroborated one another, from the testimony of other witnesses in the case, as well as from non-testimonial documentary evidence that is in the record. I will first start with the accused's own statement. And within that, I will focus on certain specific admissions that he made. As we know, Mr. Mustafa was interviewed by the Specialist Prosecutor's Office as a suspect. He had the lawyer present and was advised of his rights, including his right to remain silent. Let's watch a short clip from the SPO interview where he confirmed the propriety of the interview process.
Can you confirm that you gave the statement voluntarily? You were not threatened or forced in any way to do so?
A ka mundësi që të konfirmoni që ju e keni dhënë këtë deklaratë me dëshirën e lirë dhe nuk keni kërcënuar apo detyruar në asnjë lloj mënyre për ta bërë këtë gjë?
Sakt.
That's correct.
Can you confirm that you were not given any promises or guarantees in return for providing the statement?
A ka mundësi që të konfirmoni që nuk ju është dhënë asnjë lloj premtimi apo garancie që të jepni këtë deklaratë?
Sakt.
That's correct.
Do you have any objections to the manner or process by which this statement was taken?
A keni ndonjë kundërshtim për mënyrën ose procesin nëpërmjet të cilit është marrë këtë deklaratë?
Jo, manager.
No, I
Ka
don't.
qenë korrekt.
I believe to have been right.
So as we could see and hear, Mr. Mustafa confirmed he did not have any objections to the manner the interview was conducted and the way the statement was taken. Now, before going into important aspects of his admissions, I think we have to answer one question. How should we assess Mr. Mustafa's statement? When assessing his interview with the SPO, when comparing the content of that interview to the evidence in the case, Your Honors will see that he tried to walk a very careful line. Let's not forget that he was interviewed as a suspect. As such, he walked the fine line between appearing credible and not admitting responsibility. He admitted what he had to. He denied what he had to. He admitted those facts that would be hard to refute because of the evidence available on them that he knew about. For example, he admitted being at the Slash detention compound during the time frame of the charges. He admitted being in charge of BIA. He confirmed the identity of specific members of BIA. And Your Honors, significantly, in brackets, those were soldiers named by the victims as participating in their beatings, in their mistreatment. Mr. Mustafa even admitted hearing rumors of civilians being detained at the Slash detention compound. But he stopped there, to hearing rumors. He knew that if he had admitted even only a little more, for example, that people were for a fact detained and abused at the Slash detention compound, that it was not just a rumor, he could not escape responsibility for those crimes, as he was the one in command there. The admissions he made are significant, no doubt more significant than Mr. Mustafa realized at the time. And they powerfully corroborate the victims in key aspects. Let's discuss these admissions in a little more detail. I will start with the admission regarding time and place. So first, the accused made important admissions concerning time and place relevant to the charges. He admitted he was in Slash during the indictment period. He started by explaining that between the 25th of March and the 22nd of April 1999, he stayed in Slash. He, and I quote, slept there overnight 2 or 3 times for a couple of nights, unquote. He specified that he left Slash at some point between 12 and 14 April 1999 and confirmed that he was present in Slash before this date. More specifically, what he said was that he was there, and I quote, perhaps 15 days or 20 days before the offensive, unquote, which, according to him, commenced on or about 16 April 1999. Second, the accused admitted his presence not just in Slash, but specifically at the Slash detention compound, confirming that when in Slash, he stayed in one of the buildings of the Slash detention compound. He confirmed that some BIA soldiers were based in Slash and that they used as a safe house the compound that we have seen on the screen, the compound that the SPO has referred to as the Slash detention compound. So why are these admissions regarding time and place important? Your Honors, because they match and therefore corroborate the evidence given by 1679 and 3593 with regard to the time, that is the beginning of April 1999, when they saw the accused in Slash because he participated to their beatings and mistreatment. They are important because they confirm the place, the very same place, the Slash detention compound, where these victims say they were interrogated and mistreated by the accused. So we know from the accused that he was there. Mr. Mustafa's admissions on time and place also match and thus corroborate the evidence concerning when and where the murder victim was delivered to the Slash detention compound in his presence, in the presence of the accused. To sum up, Your Honors, the accused admits that he was at the Slash detention compound in early April, at the same time, early April, when 1679, 3593, and 4600 say they saw him there. Now the question is, if these witnesses were making up their stories, how is it possible that they picked as the time when they saw the accused at the Slash detention compound, that they picked the exact time when the accused himself admitted he was there? If they were making it all up, how could they have possibly known that Mr. Mustafa was there at that time? The answer is they could not. The probability of such coincidence is in fact zero, and thus just not happen in objective reality. The fact that the accused admits he was at the Slash detention compound at the time he said he was is a powerful corroboration of the account provided by the victim's witnesses. I will move to a second admission, which is also important. The accused admitted that he was the one in command of BIA, including the unit's members whom we know from witness evidence were stationed at the Slash detention compound in April 1999. The accused was the only commander of BIA throughout the unit's existence, as he said. He was the unit's ultimate authority, as he phrased it himself, and we now see it on the screen as an excerpt. I was at the headquarters. The accused had the power to nominate his subordinates to various positions in BIA, including his deputies, head of sectors, and to discipline them. His commanding power over his soldiers was evidenced by the orders he was imparting to them and which were executed. We have in evidence several examples of those orders, including one concerning an attack on a Serbian fuel depot conducted in March 1999, which the accused discussed in his interview. Again, why are these admissions important? Because Mr. Mustafa's admissions about his role and about his command over the soldiers in BIA match, again, the evidence given by 1679 and 3593, amongst others, of course. These witnesses said that the accused was referred to by others as commander. They also saw, while they were held at the Slash detention compound, that he exercised authority over the soldiers there, over those soldiers who engaged in the abuse and torture of the detainees. Again, powerful corroboration of the evidence provided by the victims, which cannot be read as a mere coincidence, especially since the victims did not know Commander Salih when they were taken to Slash. They could not know about his title or authority. They didn't. The third important admission of the accused is that people were indeed held in the compound in Slash. When questioned about it during the SPO interview, Mr. Mustafa first said that he knew that soldiers were held there, and he remembered two episodes, one at the end of March 1999 and one in April 1999. When pressed further, Mr. Mustafa also admitted having heard rumors that civilians, some of them allegedly being thieves, were detained in what the SPO called the Slash detention compound, which is the place where the accused said he was staying when in Slash. Mr. Mustafa said that that fact, the detention of civilians, was not a secret. He added that he heard that some of those civilians were released in the wake of the incoming Serbian offensive, but he maintained that he did not see them himself. Note here how carefully the accused walks the line in his statements. He tries to admit as much as he has to, because he knew those detentions were known, were not a secret, while underlining at the same time that he had nothing to do with the detention of civilians. So what was his actual knowledge of the victims being detained and abused? What was his actual participation in interrogations and beatings? Those were turned in the interview into rumors that civilians were being held at the very location he commanded, at the very location where BIA soldiers were stationed together with him. In the end, even this careful and strategic admission by the accused corroborates the victims in this case. They testified how they, as civilians, were detained, and that some of them, including the victim, who was later murdered, were accused of being thieves, and that most of them were released around 18-19 April as the Serbian offensive was approaching. A fourth important admission of the accused that corroborates the accounts of 1679 and 3593 is that he identified and named 3 members of BIA specifically mentioned by these victims. In particular, the accused acknowledged that a person nicknamed Tabuti, which means coffin, as we heard at trial, with the real name of Nazif, was indeed a BIA member. Your honors will remember that the nickname Tabuti was heard by the victims by 3593 and 1679 at the Slash detention compound as belonging to one of their chief tormentors. 2 other soldiers confirmed by the accused among the BIA members were Brahim Mekmetai Bimi and Ilmi Vela, Vedekya, death. He was known as such. Again, their names were both mentioned by one of the victims, 1679, among those of the soldiers in Slash who participated to his mistreatment. Your honors will remember that witness 01679 even recognized Bimi. Now, the naming of these 3 individuals independently by the victims on one hand and by the accused on the other is again a powerful corroboration of the evidence provided by the victims. If they were making up their stories, as the defense now contends, would they be able to specifically name people who participated in their abuse? People whom the accused himself, in his own interview, admits were in fact members of BIA? What is the chance of that happening? The chance is 0. The victims provided those names because they were at the Slash detention compound. They were detained there, they were abused there by the accused and his subordinates, whose names the victims heard at the Slash detention compound and clearly remembered and testified about very courageously. And as I said, W01679 even recognized physically Bimi. Now, and a further note aside is interesting to be made at this point. While the accused admitted that Coffin, Death, or Bimi were members of BIA, he did everything he could in his interview to minimize their roles, protecting both them and himself. He no doubt knew that, as close associates, any responsibility for the crimes that fell on them could also fall on him, their commander. This extrication strategy of the accused was particularly visible with regard to his former deputy in BIA, Brahim Mekmetai, also known as Bimi, whom Mr. Mustafa tried to remove from the scene, claiming that Bimi was never or was rarely in Slash. I quote from Mr. Mustafa's interview. Bimi never stayed in Slash. He might have visited for an hour or two, but he did not stay in Slash, unquote. This is from part 8 of the interview. Your Honors will remember how close to this version of the facts, the evidence that Mr. Mekmetai provided to the SPO when he was also interviewed by the SPO as a suspect was. And he was interviewed by the SPO as a suspect some months after Mr. Mustafa had been interviewed as a suspect. Mr. Mekmetai, in the SPO interview, never mentioned being in Slash in April 1999. Your Honors will also remember a call log, which is now on the screens, extracted from the phone of Mr. Salih Mustafa, which was seized by the SPO. Your Honors will remember that this log established, and we see the specific entry highlighted on the screen, that Mr. Mustafa and Mr. Mekmetai spoke the day before the SPO interview with Mr. Mekmetai, at the minimum. They then communicated again just 5 minutes after the conclusion of the SPO interview. And we will now see the relevant excerpt of these other phone calls on the screens. Your Honors will also remember how Mr. Mekmetai's account of the times he was in Slash changed substantially during his in-court testimony in this case, and that Mr. Mekmetai then placed himself in Slash in April 1999. The SPO showed during cross-examination why he did so, why he changed his account and tried to help the accused defense. The accused adopted the same extrication strategy with regard to Ilmi Vela, also known as Vetekia, death, whom the accused allegedly demobilized in March 1999, shortly before the events charged in this case. In this way, Mr. Mustafa provided Mr. Vela with a convenient alibi for whatever happened in Slash in April 1999, and he further distanced himself from the crimes that Vela participated in, as we heard from the victims' witnesses. Beyond these 3 individuals whom the accused confirmed as BIA members and who were named by the victims as being present in Slash, there are also 2 other BIA members whose names were connected to the events in Slash. These are Darden and Shuti. These are nom de guerre nicknames. Darden was identified at trial as Kutim Chirimi. Wartime photographs seized from the USB drive on Mr. Mustafa's person at the time of his arrest show Mr. Mustafa and Darden together. Let me just give you 2 examples of those photos. We have a first one now on the screens. We can see Mr. Mustafa in the middle with the red beret, and Dardan is the soldier on the right-hand side of the photo. He is circled in blue. The faces are blurred for the public screening of this photo. A second photo. Again, we can see Mr. Mustafa with the red beret kneeling down in the front part of the photo, and Dardan is the person circled in blue. They're all together. Again, the faces are blurred just to allow for public screening. Your Honors will remember that witness 1679 named Dardan as one of the perpetrators of the abuses he underwent in Slash. Let's move to Shuti. Defense witness Muhammad Ayeti confirmed during his in-court testimony that his nom de guerre was Shuti, that he was a member of BIA, and that he was in Slash at the beginning of April 1999. Your Honors will remember that Shuti was mentioned by a witness as one of the guards at the Slash detention compound. And your Honors will also remember that Mr. Mustafa had Mr. Ayeti's number registered in his phone directory as Shuti AAK. In sum, these identifications of Mr. Mustafa's associates in BIA are a further powerful corroboration of the evidence provided by 1679, 3593, and 4600. These witnesses would not have been able to name Tabut, Ilmivela, Dardan, Bimi, or Shuti had they not met them at the Slash detention compound in April 1999. I will address one remaining point of the accused admission, which will take us to the break. A fifth important admission that the accused made during the SPO interview is that during the war in Kosovo, he wore a red beret. A red beret that was not part of the standard BI uniform. And he said also that there was no one else in Slash, to his knowledge, whom was referred to as Commander Salih and also wore a red beret. Your Honor, this admission, again, is significant. You will remember that witness 3593 identified the person who interrogated and mistreated him in Slash as wearing a red beret. When the accused was arrested, the only photograph he was carrying in his wallet was the photo you can now see on the screens. And what was he wearing in that photo? He was wearing a red beret. So this red beret was a particularly distinctive feature of the accused, whereby he stood out among other KLA members. For example, this is evident in the photo now on the screens, which again was seized from the accused. The red beret was a very memorable feature, and it was so for W03593. To him, the red beret made Commander Salih stood out among other KLA members. The Honors will remember that when he was asked in court to describe that red hat, W03593 said, and I quote, "So it was like the other hats, but it was red. I think that was for the fact of making him distinct from the others. He was the only one to have a red hat. Nobody else had a red hat," unquote. Your Honor, as I will now move to the mutually corroborative accounts of the victims, I think this is a good place for the break. Thank you.
Thank you, Madam Prosecutor. We will then now take a break. We will resume in 30 minutes. The hearing is adjourned.
All rise.
Please be seated. Okay, we will continue with the closing statements by the SBO, but before I do that, I check the appearances. I see there that you are in the same composition.
The same composition, Your Honors.
Very well, and that also goes for the Victims' Counsel. I see you nodding, and the same goes for the defense team. Very well. Specialist Prosecutor's Office, you have the floor.
Thank you, Your Honors. I will continue on corroboration of the evidence presented by the Specialist Prosecutor's Office at trial, moving now to discuss how the accounts given by the victims are mutually corroborative. The witnesses corroborated one another, as I will be discussing. First, the victims confirmed seeing one another at the Slash detention compound in April 1999, and in their respective testimonies, they explained what they knew about one another. For example, W01679 saw 6 other detainees, including the murder victim, W03594, 3593, 4669, and a young man nicknamed Burmak. Second, the victims provided very similar stories concerning the way they themselves, as well as the other detainees whom they met at the Slash detention compound, were arrested and taken there. For example, 1679 and 3593, independently from each other, gave the same information about another witness, W03594, and the reasons for his arrest. The same information was the one that W03594 provided himself. Third, all the victims detained in Slash consistently described the place of their detention and recognized it in photos shown to them during their in-court testimonies. The respective descriptions, moreover, are consistent with the descriptions provided, for example, by defense witness Selatin Krasniqi, as we said, a BIA member and a relative of the owners of the Slash detention compound. Just to give an example, the internal layout of the building where the detainees were interrogated, as described by V01679, matches the description provided by defense witness Mr. Selatin Krasniqi when describing the same building, and in particular the upstairs part of that building that we saw marked with a red vertical line on the door. They gave the same description, that is, the inside part was composed of 2 rooms, one on each side of a corridor. Fourth, the victims corroborated one another's physical conditions and were consistent about the type and nature of the mistreatments and torture received, in particular by the victim who was later murdered, as well as the dire conditions in which he was in which they all saw him. Fifth, the witnesses testified to similar tools of abuse. For example, both W03593 and 1679 said that they were beaten with a baseball bat. W01679 was burned with a hot iron, and 3593 witnessed burn marks on the body of the victim who was later murdered. 1679 said he was electrocuted, and 3593 indicated that he was told from other witnesses that the perpetrators were using electrocution as a means of torture. Sixth, W03593 and W01679 identified several BIA members as present at the detention compound and participating to their beatings. As I have already pointed out, both victims, 3593 and 1679, identified a man nicknamed Tabuti, Coffin. 1679 also mentioned Ilmi Vela, Aka Vedecchia, as well as Afrim, Dardan, Bimi, and Fatmir. These were all BIA members, as confirmed by the accused, and also by other evidence, including W04600, Ahmet Ademi, and Brahim Mehmetai Akabimi. And the details of these are in the SPO final trial brief. Further, W01679, 3593, and 3594 provided almost identical descriptions of their release from the detention compound on or about 19 April 1999. For example, they all confirmed the order in which they were released and the fact that the young man nicknamed Burmak and the murder victim were not released. They also gave matching accounts concerning a certain visit that they all paid immediately after their release. In sum, Your Honors, on so many points, the victims corroborated each other. It bears recalling that all victims gave their evidence independently from one another at different times and not even necessarily knowing one another or knowing of others being witnesses in the case. To believe that their accounts were fabricated requires believing not just that each of them invented the story that they testified to under oath, but that they all also colluded to make up the very details of their stories before they were even interviewed during the investigations in this case. This is a wholly improbable theory, a sequence of plots that does not occur in objective reality. And that is not all. Not only did the account of the victims was mutually corroborative, their evidence was also corroborated by other witnesses in the case and by testimonial documentary evidence. For example, several witnesses put the accused at the detention compound during the indictment period, not only the victims. For example, witness 4600 testified about seeing the accused at the compound at the beginning of April 1999, thus supporting the evidence of 1679 and 3593. Further, the presence of the accused both in Slash and at the detention compound during April 1999 was also confirmed by a number of other witnesses. For example, Sedi Veseli, Fatmir Sopi, and defense witnesses Teuta Adri and Selatin Krasnici. For example, to take one of them, Teuta Adri testified that she saw the accused one night before the Serbian offensive and on the day of the offensive at the detention compound. This is a powerful piece of evidence showing that the accused was at the detention compound precisely on the day of the release of the detainees. The presence of the accused, the commander of BIA, indicates that he was the one who decided which prisoners would be released and which prisoners would not be permitted to leave. Also, several other witnesses confirmed the identities of BIA members mentioned by 1679 and 3593, as well as by the accused, as we already discussed. These witnesses include, for example, Fatmir Sopi, Sedi Vesseli, 4600, as well as defense witness Muhammad Ayeti, also known as Shuti. Moreover, several witnesses independently testified to Salih Mustafa's command and authority over the Slash detention compound. They primarily include Mr. Fatmir Sopi, Mr. Sedi Vesseli, and W04600. These witnesses also confirmed that BIA and Brigade 153 were distinct units and that no brigade soldiers were stationed in the Slash detention compound. Further significant corroboration about the involvement of BIA comes from a family member of the victim who was later murdered, who learned from the victims just after they were released that they had been held and detained by Skifterat. That Skifterat was managing the prison where they were held, and that the detainees had all been mistreated there, including the victim who was later murdered, who was treated worse than any of the others. We know Skifterat was another name for the BIA unit. So if we think about that, just hours after being released, the victims said who was responsible for their detention and abuse. This is yet another strong corroboration of the victims' testimonies and of the accused's responsibility for what happened to them. Evidence coming from defense witnesses also provided further corroboration to the evidence of the victims concerning the possibility to perform electrocution at the Slash detention compound, which they said it was used as a means of torture. For example, defense witness Ibadete Canolli referred to the use of car batteries in April 1999 to provide light inside of the buildings. This corroborates the account given by 1679 with regard to the use of what he called electricity boxes at the Slash detention compound. Further, we heard it was confirmed that there was electricity at the Slash detention compound at times. Your Honors will remember that defense witness Teuta Adri testified that there was a functioning TV set at the Slash detention compound when she was there in a certain time in April 1999. In addition to testimonial evidence, the evidence of the victims is also significantly corroborated by documentary evidence in the record. And I will be discussing here now a document that we called the list of prisoners. Your Honors, I would request that the next few slides be not broadcast to the public so that we look at them only inside of the courtroom. Can I confirm that? Okay, I will proceed then. So the document that we now see on the screens just inside this courtroom is an original document in Albanian, which lists a number of people detained in Slash in April 1999. We can see on the screens the first page of the list. Your Honors can see the names of the prisoners marked in red. Starting from the top, those names include the murder victim, 3593, 3594, 1679. The document indicates the dates of their arrest, consistent, by the way, with those stated by the victims, and also some other personal details, including names of their fathers, dates, places of birth, as well as their place of residence. Besides the names and detention of the victims themselves, the list of prisoners also corroborates other aspects of the evidence heard from witnesses in this case. First, it contains the names of as many as 19 detainees. And this is consistent, for example, with what W03593 indicated in his testimony when he said that the KLA, and I quote, "We're bringing people every night. We have been up to 17 people in that same room," unquote. Second, the document corroborates the testimony of W3594. Can I please confirm that also the next slide is kept in the courtroom? Thank you. So, Your Honors, you now see a further page from this document on the screen. The document contains, in fact, what appears to be notes taken during the interrogation of W03594. One of the answers of the witness recorded in these notes that we see on the screens corroborates the fact that the witness, as he testified, I can give the quotes, it's pages 1034 to 1035, that the witness met with certain people and discussed with them certain issues appearing on the screen. I will not further specify them due to the protected status of the information and of the witness. The Honors can, however, see these entries both in English and in Albanian on the screens. Finally, I will move to the next page, also confirming that the page is to be kept in the courtroom. This is a page of notes within the same document, which contains an annotation. This annotation says, "For Salih." The Honors can see the English and the Albanian on the screen. Overall, the document containing the list of prisoners offers a high level of corroboration to the evidence presented by the witnesses in this case. Its authenticity is proven by the very aggregate details of its contents. These details could have only been compiled by those who imprisoned the victims. In fact, the victims were together as a group only one time in their lives, and that is when they were together in Slash, detained at the Slash detention compound. So this list, with that information that we have seen, could have only been created then. Finally, other documentary evidence on the record corroborating the victims are medical records and forensic reports presented at trial, which corroborates the accounts of the victims, their condition, what happened to them. In order to remain in open session, I would just refer Your Honors to paragraphs 186 to 191 of the SPO final trial brief. A corroborating medical record that I can mention is the one belonging to the murder victim, a medical record which was found shortly after the war in one of the buildings of the Slash detention compound. This, in conjunction with testimonial evidence we heard about the document, confirms that the victim who was later murdered was indeed detained at the compound. He was there, as testified by 1679, 4669, 3593, and 3594. Your Honors, I will now leave the floor to my colleague, Mr. Michalczuk, who will continue with the SPO closing statements by discussing issues of credibility of the evidence presented by the Specialist Prosecutor's Office. Thank you very much.
Thank you, Madam Prosecutor. Mr.
And please
Prosecutor.
allow us a couple of seconds
Yes.
just to change position. Thank you.
Mr. Prosecutor, you have the floor whenever you are ready.
Maybe I can already specify that the slides that were to be kept inside the courtroom are now over. So from the next ones onwards, they can be again broadcast to the public. Thank you.
Your Honors, let me now move on to the discussion about the responsibility of the accused. The responsibility of the accused for the crimes charged in the indictment is proven by the testimony of the victims, as we have just discussed. And these testimonies of the victims are corroborated by several other evidentiary clusters. First of all, they are confirmed by the admissions of the accused. Second, they are confirmed by the testimony of each of the victims corroborating the others. Third, they are confirmed by the testimony of other witnesses, including the defense witnesses. Fourth, they are confirmed by the documentary evidence. And fifth, they are confirmed by the conduct of the accused during the investigation. Allow me now, Your Honors, to return to the victims and their testimony, and let's look at it again to consider just the issue of their credibility. Let's discuss specifically the evidence of the two victims who identified the accused as being present for interrogations and beatings, victim 1679 and victim 3593. I will start with 1679, Your Honors. This witness was a direct victim of the accused's criminal conduct. He consistently mentioned the accused as Salih or Commander Salih across all his statements, starting from the very first one, where the nickname Salih already features. This witness told the same story from the very beginning. Even in an environment of intimidation of witnesses, he mentioned the accused from the very outset. Further, this witness did not embellish the evidence that he provided and did not enrich it across time, which you would expect if he were falsely blaming the accused. In fact, this witness testified that Commander Salih personally participated in beating him just one time. That is when the witness was first taken to the / detention compound, during which time he also gave orders to the others. Witness 1679 testified that Commander Salih was not present during all the beatings, and that on the other occasions when he was present, he did not beat the witness, but he looked on and made fun of him while his comrades were beating 1679. This witness credibly testified that he knew who Commander Salih was, because the other soldiers told him that they were taking him to speak with the commander. This witness knew that, as the commander introduced himself as Commander Salih. He also knew, because once inside the room where the commander beat him, he heard the others referring to him as Salih. 1679 also explained that the others addressed the commander by asking, and I quote, "What shall we do, Salih? What shall we do?" That witness confirmed that also the murder victim knew who Salih was. And finally, 1679 recognized Salih in two photographs that were shown to him by the trial panel in this very courtroom. The evidence of witness 1679 is powerfully incriminating, but it is also restrained. He did not embellish. He did not claim that the accused participated in all the beatings. He might have done so if he were making it all up, as the defense now claims. Moreover, the evidence of this witness, 1679, remained consistent throughout his in-court testimony and was also consistent with his prior statements. There were some details he could not recall or minor inconsistencies in his evidence. This is true. However, those are exactly what one would expect from a witness being called upon to recall every detail of events that occurred more than 20 years ago. To the extent that there were errors in the witness's prior statements, 1679 was insistent on clearing them up and explaining what he remembered. For example, when he was confronted with seemingly divergent accounts concerning the people who took him from the Slash school and brought him to the detention compound, this witness explained that he remembered he did mention Bimi also in the past, in his prior statements. He was adamant about that and indicated that the statement taken back then did not adequately capture what he intended to communicate, considering the different conditions under which he testified and how he felt at that time. A striking and unplanned confirmation of the witness's ability to identify his perpetrators occurred when Brahim Mehmetai Bimi testified at trial. 1679 immediately recognized him as the same Bimi who participated in his mistreatment at the Slash detention compound, even before Mr. Mehmetai acknowledged that his nickname was indeed Bimi. Witness 1679 on that day was watching the proceedings on television, and he promptly recognized Bimi as he appeared on the screen. Your Honors know that this is confirmed by a text message that the witness sent that is in evidence. In that message, 1679 wrote that he recognized Bimi as the one who mistreated him in Slash. And again, this message was sent before Mr. Brahim Mehmetai said in his testimony that his nickname was Bimi. The identification of Bimi by this witness in an unprompted test 23 years after the events in Slash corroborates and supports his identification of Bimi as one of the people who tortured him. But it also demonstrates his ability to identify the persons involved in his abuse and torture, including the accused. It was an objective test of the witness's ability to recollect what he saw and what he remembered. A test that the witness, Your Honors, passed with flying colors, and the court should heavily factor it in when assessing his identification of the accused. Your Honors, I will now turn to the second witness in this case, 3593. This witness indicated the reasons why he was sure that his tormentor in Slash was indeed the accused, that it was indeed Salih, and how he identified him. The witness first saw the accused in Slash on 3 occasions. During the first beating that took place on the same day when he was arrested and taken to the detention compound, then during the second beating that took place a few days later, and then when the accused came at one point to the barn with his soldiers. During the first beating, 3593 looked up once and saw the accused, who was wearing the red hat, as the witness put it. Even if it was dark, the witness was still able to see the accused in the light of the torch, as he said himself. And he could see the accused as the accused was wearing exactly that distinctive red beret that we discussed before the break. On that occasion, the accused had no mask on his face. What made 3593 remember the accused particularly well was also a traumatizing and memorable experience in the course of which the accused put the pistol to the head of the witness and pulled the trigger. The witness characterized that particular moment as horrifying and described it consistently in all of his statements. Let's move on to the second beating of this victim. During this second beating, the sack was removed from the witness's head, and he could see the accused clearly. The accused was in uniform, again wearing the red hat, and was the only person beating the witness with the baseball bat. The witness also heard the accused's nickname Salih when he was in slush. As he explained, he heard it once when he was put before the accused. At that point, someone said, and I quote, "Here, here, here, Salih," and also, "Commander Salih, what to do?" The witness then clearly heard that the accused was called commander. He also confirmed that the accused was indeed a commander in slush a month after his release, in his conversation with KLA soldiers from the area. Your Honors, 3593 has no reason to lie and no reason to falsely implicate the accused. He does not otherwise know the accused, has no personal bias against him, and actually had a strong incentive not to name a KLA commander, given the climate of witness retaliation and intimidation in Kosovo. Also, as with witness 1679, the testimony of 3593 was restrained. He did not embellish. If he were going to lie, to falsely implicate the accused, he would have mentioned the accused at every beating, participating and overseeing his torture and the treatment of others, every time it happened. But the witness did not do that, Your Honors. He did not try to add to or improve his story to make it more incriminatory. Nonetheless, should the court be concerned that 3593 did not mention the accused in his initial enemy statement, but did so only in his SPO interview and later in this court? Your Honors, there are, in our view, several specific and compelling reasons why the witness behaved in such a way. These reasons include primarily fear. Fear stemming from the pervasive climate of witness intimidation and impunity regarding former KLA members in Kosovo. Since the end of the war in Kosovo and until today, those willing to come forward and testify with regard to the alleged crimes committed by the former members of the Kosovo Liberation Army, they all have faced an existential dilemma: to remain silent and continue living in the world of lies and fear with the sense of guilt for doing nothing, or to seek justice and truth, facing social ostracism and putting themselves and their families in danger of retaliation. The first choice is, at first glance, easier and has been the choice of many. The second option, chosen by very few, requires a lot of courage, determination, and the support of loved ones. Those few who dared speak the truth have faced very strong headwinds, as the conditions in Kosovo have not been particularly conducive for them as witnesses. Before the creation of the Kosovo Specialist Chambers, what many in Kosovo observed and were convinced of was a pervasive climate of impunity for crimes committed during the war of 1998 to 1999 by former KLA members. This perception was justified and was evidenced by a low number of successful prosecutions. Many in Kosovo believed that those in the KLA were still powerful in the official Kosovo institutions and were in fact controlling them. This was remarked, for example, by one of the witnesses, witness 4669. This witness testified that when some years ago he was approached by another detainee with the suggestion to reporting about what happened to them in Zlash, this witness felt that it was not the right time because, and I quote, all the institutions were held by those people. This witness added that he did not trust institutions back then. This court, Your Honors, in this case, has proven to be a forum where witnesses such as 4669 and the other victims could finally tell their stories. In this respect, the creation of the specialist chambers was a breakthrough moment for these witnesses and, more broadly, for justice in Kosovo. The lack of forum was, however, not the only factor dissuading the witnesses. Another was a social and cultural climate that persists to date. In a tightly knit society where ethnic identification and loyalty can surpass an allegiance to the state and its official authorities, cooperation with the investigative institutions against former KLA leaders like the accused can be an anathema going strongly against local norms. In such a climate, witnesses giving evidence against the KLA members have faced, as a minimum, social ostracism and exclusion. Another important element that strongly discouraged many witnesses and victims to speak up was the fact that many of them were labeled, even without evidence, as Serbian collaborators and spies. And in the post-war period, that classification was extremely dangerous for those concerned. Even after 23 years, this consideration is still surprisingly strong and valid, as was eloquently put by witness 4676, and Your Honors have it right now on the screen. This witness said, "Fear exists all the time, yes, and it's out of some misunderstanding that people could think of. It's a fear of being pointed out, fear of being labeled as a traitor, a collaborator, somebody who wishes ill on other people, somebody who has betrayed the values of freedom and values of the war, and that comes out of a mindset that exists among us." For all the aforementioned reasons, Your Honors, the fact that witness 3593 did not mention the accused in his unmixed statement should not be held against this witness and should not have any significant impact on his overall credibility, including the identification of the accused. As he clearly indicated in his unmixed statement, and you have, Your Honors, this quotation on the screens, "I wanted to give a statement immediately," said that witness, "when I was released, but for the security of my children and me, I did not give a statement to anybody." The witness then dared to inculpate the accused only when he felt more safe. More safe, Your Honors, not safe, more safe. Because even today, after 23 years, when he testified in this very courtroom before the panel of the Kosovo Specialist Chambers, the fear of the witnesses was still evident. Your Honors remember his repeated and persistent refusal to mention the name, surname, or even the nickname of the accused. Even if the witness's own SPO drawing was shown to him in court, with the name Salih clearly written on it, he still refused to confirm that the word Salih was written there. Instead, he said, and I quote, "I don't know, I don't recall." When the examining prosecutor put it to him twice, he said, "Yes, I understand. This is the name of the accused. So I refuse to mention his name. I said that yesterday as well, and I don't want to ever mention his name in my life." Your Honors, did 3593 appear to be a witness who was adding the accused to his testimony? Was he the one who was falsely implicating the accused? No, Your Honors. He was just a reluctant and afraid witness who resisted implicating anybody in his initial statements and only just managed to tell his full story in this court. Your Honors should also consider, in relation to this witness, the significant evidence stemming from the conduct of the accused during the investigation. That conduct strongly indicates the accused's involvement in the crimes charged. The name of witness 3593 appeared in a message sent from an associate of the accused to the accused. That message was sent shortly after Salih Mustafa was summoned for an interview by the SPO. Why is it that significant? Why is this communication that significant? It is significant, Your Honors, because it shows that the accused knew 3593 was a potential witness against him already at that time. It is significant because it shows that the accused knew that 3593 had been detained and abused at the Slash detention compound. Let me explain that in more detail. On October the 16th, 2019, the accused received a summons to appear before the Specialist Prosecutor's Office for an interview in the capacity of a suspect. Just 4 days later, on the 20th of October 2019, the accused's associate sent him a mobile communication containing the name and surname of witness 3593. Was that a coincidence, Your Honors? This is highly unlikely. In fact, this is impossible. Let me put it simply. 3593 and the accused had no contact after the war, and there was no connection between the two apart from the imprisonment and torture that 3593 received at the hands of the accused and his soldiers in Bia. Moreover, SPO had interviewed 3593 in secrecy just a few weeks before that mobile communication, and the accused had no way to know at this point about that interview. So, the only reasonable explanation for the name of 3593 appearing in the text message that I have mentioned is that the accused and his associates independently knew that 3593 was a victim at the Slash detention compound and that he could be a potential witness against the accused. Witness 4600 testified about seeing the accused at the Slash detention compound at the beginning of April 1999, which was in fact, by putting all the evidence together, the 1st of April of that year. That date, as your honors are aware, is of great significance in that case. Witness 4600 was consistent in recounting his story both during the investigation and in court. His account regarding the events that took place on the 1st of April was clear, it was detailed, and it was corroborated by other witnesses, including 4603, 4390, 4391, 4674, and witness 4648. Witness 4600, knowing that he might be inculpating himself, nevertheless provided his evidence without embellishing it or attempting to remove himself from the picture. There is no reasonable explanation as to why he would have lied about what he did and about his own involvement in this case. The evidence of this witness also confirmed that members of BIA included Dardani and Nazif Musliu, known as Tabuti. Apart from these two members of BIA, witness 4600 particularly identified another BIA soldier nicknamed Shuti, who was in fact the defense witness Muhammad Ayeti. Muhammad Ayeti came to this very courtroom and confirmed his nickname Shuti, confirmed that he was a BIA member in 1999, that he was in Slash in April 1999, and that people indeed called him Shuti. You may also remember from the evidence that the accused himself that he called Mr. Ayeti Shuti and that he had him saved in his phone directory as Shuti AAK. In sum, Your Honors, all three witnesses, that is 1679, 3593, and 4600, provide evidence that can be credited by this court, confirming the presence of the accused in Slash, at the Slash detention compound, and in periods confirmed or admitted by the accused himself. Your Honors, I would like to very briefly, in the context of all the evidence in this case, discuss also the conduct of the accused in this investigation. I have already mentioned one episode of that conduct concerning witness 3593, where his name was revealed to the accused in the message sent to the accused. But in addition to that episode, the accused also actively tracked investigations about him and displayed his intent to interfere with those investigations. 3 examples demonstrate that. The first example. Shortly after the war, when asked about the ongoing ANMIC investigation into the events in Slash, the accused said, and I quote, "There will be no case. There will be no trial." He added, and I quote, "For as long as I am here, this case will not go ahead." And as the accused correctly predicted, no case was indeed initiated. Salih Mustafa was at that time an officer of the Kosovo Protection Corps. The second episode, and this one regards the SPO investigations particularly. The accused was in frequent contact with his former BIA comrade, Mr. Kwitim Cherimi, aka Dardan, informing him in real time about developments in this case. The two men had an SMS exchange with each other concerning Brahim Mehmetai, Bimi, who had just been summoned as a suspect by the SPO. That exchange indicates that the accused and Quitim Cherimi wanted to meet with Brahim Mehmetai before his trip to The Hague. They did so in order to coordinate his evidence with that of the accused and to obstruct the SPO's investigation of the crimes at the Slash detention compound. The third episode, Your Honors. After the interview of Mr. Agron Jamaili, another suspect in this case, the accused and Quitim Cherimi spoke again, and Quitim Cherimi said in his communication to the accused, and I quote, "There are ways to deal with that, to solve this business." Your Honors, Mr. Mustafa's conduct during the investigation shows his consciousness of guilt and his awareness of evidence implicating him in the crimes committed at the Slash detention compound. It also shows his intent to hinder efforts to get to the truth. Having discussed that, Your Honors, I would now address the defense case with your kind permission. This defense revolves mainly around the claim that the accused could not have committed the crimes in Slash as he was elsewhere during the indictment period. To refute the prosecution case, the defense put forward several witnesses who attempted to place the accused in various locations in Kosovo in April 1999. Some of them claimed to specifically have had interactions with the accused in the first days of April 1999. Let me be clear from the outset, Your Honors. The defense's evidence does not establish that Salih Mustafa was not in Slash during the indictment period. Even considered on its own, separate from the evidence offered by the prosecution and the accused's own admissions that he was in Slash, the defense witnesses do no more than indicate that Salih Mustafa moved around during the indictment period and was at times at locations other than Slash, such as Pristina, Butovc, or Barileve. However, all of these locations are accessible from Slash within a few hours, and there is no evidence that the accused was not in Slash at critical moments during the indictment period, or that he is not criminally responsible for the crimes charged in the indictment through multiple forms of liability. It is true that moving throughout the area in April 1999 was at times challenging because of the occasional presence of Serbian forces and the topographical characteristics of the terrain. However, the evidence also shows that the accused was still able to move around in those conditions. We know that the accused had access to vehicles that he used to move from place to place. For example, witnesses Bislim Nereci and Avni Gashi specifically indicated that in April 1999, the accused moved in a Volkswagen Golf 2, a four-wheel drive. Also, witness Nazmi Verbovci and Fatmir Humoli mentioned that the accused was using a car, as confirmed by Teuta Hadri and Salih Mustafa himself. In April 1999, there were cars and other means of transportation in Slash, which, as a commander of BIA, the accused would have clearly had access to. Salih Mustafa was also able to traverse the area on foot. He knew the area particularly well, as he routinely delivered supplies to various KLA locations. He was also engaged in safely escorting KLA officials and the wounded within the zone. For all these reasons, the accused's ability to move between locations by car or on foot is without a doubt. Having said that, Your Honors, allow me to move on to a brief assessment of individual accounts of defense witnesses. In order not to repeat their evidence, my focus will be not so much on their accounts, but rather on their credibility. In some cases, such credibility was visibly influenced by an apparent bias, not only in favor of the accused, but also against this court. Why is the bias against this court so important? It is important because it impacts on the credibility of defense witnesses, where it exists to such an extent that it undermines any obligations that these witnesses might have felt to provide truthful testimony to this court. Your Honors, two defense witnesses, Fatmir Humoli and Ahmed Ademi, were put forward to demonstrate that they met Salih Mustafa in Pristina on the 1st of April 1999. You have noticed, Your Honors, how this date became important during the trial. Once the prosecution established that critical events occurred on this very date, involving the accused himself, the evidence of the defense witnesses began evolving from their previous statements, and suddenly in court, the witnesses pretended to remember very specific things about this date, which had not been the case previously. Despite the best efforts of these witnesses, their evidence does not establish that the accused was not in Slash on the 1st of April 1999. Defense witness Fatmir Humoli claimed being with the accused in Pristina for one day around the 1st of April 1999. According to these witnesses, they both left Pristina on the 1st of April early in the morning. Then they reached the village of Barileve, where they parted ways at some point in the afternoon. But this evidence of this witness is not reliable. Fatmir Humoli was uncertain about the dates of these events. He indicated different dates during his in-court testimony and different dates in the statements that he gave both to the SPO and to the defense. By his own admissions, this witness was not able to recall the exact dates, as he said, due to the passage of time. Asked about other meetings with Salih Mustafa in January or in February 1999, this witness was not able to provide any concrete dates of such meetings whatsoever. Before the court, Mr. Humoli claimed that he was suddenly sure about the 1st of April 1999, as on that day there was an exodus of the population to Macedonia passing through Pristina. However, as proven by various documents tendered at trial, including reports of international organizations, for example OEC, or several media outlets, the refugees in fact began leaving Pristina shortly after the NATO bombing campaign started on the 24th of March 1999, and their exodus continued at least until the 6th of April of that year. If it was indeed this event that helped Fatmir Humoli remember the date of his encounter with Mr. Mustafa, as he claimed, it could have been on any day within this period of time and not necessarily on the 1st of April 1999, as he claims. Further, Fatmir Humoli was not an objective or credible witness. He published Facebook posts in support of the accused and is a friend of the accused, as they were long-term comrades in the national movement for the liberation of Kosovo and the KLA Brothers in Arms. Moreover, Mr. Humoli displayed a negative bias towards the specialist chambers that raises questions about the sincerity of his oath to be truthful. He indicated that, and I quote, the court was unjustly established. He also publicly compared it to Guantanamo for the Kosovo Liberation Army. He also publicly called it, and I quote, an unfair, essentially racist court and human rights violator, and a political institution that cannot guarantee a fair judgment. Ahmed Ademi was another defense witness called to testify about meeting the accused in Pristina for one day at the end of March, beginning of April of 1999. Mr. Ademi's evidence does not provide an alibi for the accused for the 1st of April. The witness was not sure about the dates of that encounter, admitting that all he knew was that the meeting with the accused took place at the end of March or at the beginning of April. He blamed the lapse of time for his uncertainty. In sum, Your Honors, the accounts of Fatmir Humoli and Ahmed Ademi did not establish that Salih Mustafa was not in Zlash on the 1st of April 1999. Additionally, Pristina is about 22 kilometers away from Zlash, which is 40 minutes by car. So even if the accused were indeed in Pristina in the early morning of the 1st of April 1999, which has not been established by the evidence, he could have still arrived in Zlash within the same day, in time to be present when critical events occurred in Zlash on that day. Nazmi, Verbovci, and Bislim Nreci were called to give an alibi for Salih Mustafa, claiming that they interacted with him in the village of Barileve in the first days of April 1999. The accounts of both witnesses are highly problematic, but even if true, they still do not conflict with the prosecution case. Nazmi Verbovci testified that he saw the accused in Barileve on the 1st or 2nd of April 1999, where he stayed for 1 to 3 hours. Bearing in mind this short time span when Nazmi Verbovci claims he saw the accused, his evidence does not establish that Salih Mustafa was not at the Zlash detention compound during the same day. Barileve is located 31 kilometers from Zlash, which is about 30 minutes by car, and the accused could be easily in both places still within the same day. Further, Nazmi Verbovci's evidence is problematic for two particular reasons. First, he provided different dates of his encounter with the accused in his defense statement and in his in-court testimony, and was not able to convincingly explain that apparent discrepancy. In court, he focused on the 1st of April, even if he never mentioned that day before. He suddenly insisted on that date, even if, as he admitted, there weren't any specific event that one can remember around that particular date. Secondly, and more importantly, Your Honors, Nazmi Verbovci did not give his account independently, but agreed on the dates with other persons, including defense witness Bislim Nreci. Bislim Nreci discussed with Nazmi Verbovci not only the date when he met, allegedly, the accused, but also other circumstances surrounding the events that took place in Barileve on the 1st of April 1999. The account of Bislim Nreci is also not in contradiction with the prosecution case. This witness testified about meeting Salih Mustafa in Barileve in February or March 1999, and then around mid-April of that same year. This witness was also uncertain about the date of his encounter with the accused. The evidence of Mr. Nreci must also be assessed in the light of his pro-accused bias, evidenced by his supportive Facebook posts and his proven collusion with Nazmi Verbovci concerning the dates and events in Barileve in April 1999. In this context, it bears recalling that Nazmi Verbovci and Bislim Nreci have known each other since childhood. They are friends, neighbors, and meet frequently. Your Honors, Gani Sopi, Hazir Borovci, and Jakub Ismaili were all called by the defense to confirm the accused's alibi for a few days at the beginning of April 1999. According to these witnesses, Salih Mustafa allegedly spent those days in the village of Lower Butovc. All three witnesses belonged to the same KLA unit in Butovc that at some point formed part of the BIA unit commanded by the accused. They were also friends during the war and are friends today. Gani Sopi. Gani Sopi was confused with regard to the dates of the accused's stay in Butovc. He specifically indicated that he could only give approximate dates and that he would rather not refer to specific dates as he might forget them due to the passage of time. He claimed possibly remembering the dates as the Muslim celebration Eid al-Adha, or Small Bayram, took place around that time. However, this witness could not even give a precise date of that celebration, the date on which that celebration commenced. When assessing Gani Sopi's evidence, Your Honors, one should bear in mind that he has a strong familial bond with the accused, as the accused's wife is Gani Sopi's niece. The witness and Salih Mustafa are also friends, brothers in arms, and have known each other since 1996-1997. Moreover, Gani Sopi admitted following the testimony of his friends, Hazir Borovci and Jakub Ismaili, who gave evidence before him, where he could clearly notice the importance of certain dates for the criminal culpability of the accused. Jakub Ismaili said that he met Salih Mustafa in Butovc first at the end of March and then around the 7th or 8th of April 1999, and then approximately on the 20th of April of that year. None of this testimony is inconsistent with the evidence of the accused's participation and direction of the crimes as such. Further, in assessing his evidence, the court should consider Mr. Ismaili's memory problems, an issue he himself invoked several times during his testimony, as well as the fact that he's a good friend of Mr. Salih Mustafa, with whom he had stayed in frequent contact both before and after his arrest. The third witness, who allegedly saw the accused in Butovc in April 1999, is Hazir Borovci. Like his friends Gani Sopi and Jakub Ismaili, also this witness was not sure about the dates in April, indicating that he might have seen Salih Mustafa on the 2nd or the 3rd of April, and later maybe 3, 4, 5 times, as he said himself. Like Gani Sopi, Hazir Borovci gave wrong dates concerning the Muslim celebration of Eid al-Adha. That was his main signpost for his interaction with the accused. He also admitted that he did not see the accused every day. In evaluating the testimony of Mr. Borowski, what we should consider is this witness's bias in favor of the accused, which was evidenced by his supportive posts published on Facebook. Your Honors, even taken at their highest, the accounts of Mr. Sopi, Mr. Ismaili, and Mr. Borowski do not contradict the prosecution case. Butovts is located 32 kilometers from Zlash, which is about 50 minutes by car, and the accused could move to Zlash and back even on a daily basis. 3 additional witnesses were called to testify about meeting the accused for a short period of time in mid-April 1999. Their evidence also does not contradict the prosecution case. One was Kaplan Parduzzi, wounded in the Battle of Surdul on the 10th of April 1999. This witness attempted to provide the accused with an alibi for an unspecified date between the 10th and the 13th of April of that year, claiming that the latter escorted him and Nureddin Ibishi to the place called Rimanishte or Bellopoje on their way to the KLA hospital in the village of Potok. Mr. Parduzzi's evidence is marginally relevant and does not in any way undermine the proof offered by the prosecution. Additionally, the evidence of Mr. Parduzzi should be considered and discounted in the light of the condition he was in, the brevity and circumstances of the alleged encounter with Mr. Mustafa, the contradicting evidence of Nureddin Ibishi, and Mr. Parduzzi's expressions of support for the accused and against this court. The last alibi witness of the defense was Shechir Rahimi, who drove the vehicle in which the wounded Nureddin Ibishi and Kaplan Parduzzi were transported. He testified that at some point during the trip, he met 2 people driving the tractor and heard one of them calling another Salih. This witness did not know Salih Mustafa at that time and acknowledged that after 23 years, he was unable to determine whether the person called Salih was actually the accused. In sum, Your Honors, the accused's claimed alibi has been disproven beyond a reasonable doubt. There is no reliable evidence that Mr. Mustafa was not at the Zlash detention compound on the 1st of April 1999 or at other significant times during the indictment period. Your Honors, apart from the alibi, the defense attempted to prove that there were no detainees held in Zlash in April 1999 and that the accused was not in charge of the detention compound there. Muhammad Ayeti, also known as Shuti, and Salatin Krasniqi were specifically put forward to demonstrate that during the indictment period, no detainees were held at the compound. Their evidence, Your Honors, should not be given any credit whatsoever. They are both the accused's former subordinates in BIA, both admire him and consider him their friend. Salatin Krasniqi, member of the BIA unit and the son of the owners of the Zlash detention compound, claimed that he was not aware of any detainees kept at the compound, despite the fact that he stayed there, albeit not constantly, from the beginning of April 1999. The credibility of this witness is greatly impaired by several factors as demonstrated during his testimony. I'm going to give just a few examples of such factors, which should be considered as his evidence is weighed against all the other prosecution evidence. First, during his initial defense interview in February 2021, while drawing the detailed sketch of the compound that he allegedly knew very well, he intentionally forgot to draw and mark the very building where the detainees were held, even though it was rather a big and important structure within the compound. Before the court, he claimed, implausibly, that he does not remember how such a crucial omission happened. Second, even if he initially and adamantly claimed that no one was detained in Slash, he later admitted that people, including himself, were questioned by the KLA at the compound in the period after NATO commenced its strikes. Third, when asked a number of times about who was in charge of the Slash detention compound, Selahattin Krasniqi mentioned a variety of names, but remarkably, he never mentioned Salih Mustafa amongst those in command. And this is despite knowing that Mr. Mustafa was his BIA commander and despite Mr. Mustafa's own admissions on this point. Fourth, Selahattin Krasniqi attempted to remove from Slash his close acquaintance and co-fighter in BIA, Muhammad Ayeti, also known as Shuti, who himself admitted being present at the Slash detention compound. This is what Selahattin Krasniqi said in court about Ayeti's presence in Slash. And I quote, Muhammad Ayeti came in October. I mentioned it earlier. He stayed for a night or two and went towards Mayats or someplace else. I'm not quite certain, and I did not see them until the offensive. In fact, I saw him in Pristina the day that Pristina was attacked by Serb forces, and then I did not see him again until the offensive. When pressed by the cross-examining prosecutor and confronted with the account of Muhammad Ayeti, Selahattin Krasniqi reluctantly conceded, and I quote, I don't remember. I don't remember. He might have been there, but I don't remember. I can't say yes or no. Think of this, Your Honors. Selahattin Krasniqi knew Mr. Ayeti and knew that Mr. Ayeti was there, but tried to do whatever he could to remove him from the compound. He did that not only to protect Mr. Ayeti, but also to help in this way the accused's defense. In assessing Mr. Krasniqi's evidence, the court should consider the witness's strong emotional bond with the accused, exemplified by his statement, and I quote, "We are all friends, and we will remain friends until we die and after death." We should also remember that in the past, Mr. Krasniqi was convicted for the intentional crime of fraud. Muhammad Ayeti, also known as Shuti, was another witness who said that he neither saw nor heard that people were held at the detention compound in April 1999. He also denied being present where a murder victim was delivered to the compound. His evidence is both limited and unreliable. Unsurprisingly, he did not implicate himself and admit to being present when the murder victim was delivered to the Slash detention compound with the accused present. He admitted as few facts as possible and nothing that could incriminate him or his commander, Salih Mustafa. With respect to the issue of prisoners being kept at the Slash detention compound, Mr. Ayeti did not seem to even enter the compound buildings that are critical to this case. He said that he did not stay in the building of the compound used as a detention and interrogation site, and he admitted that he never visited the basement of this house where at least some of the detainees were held. He says he only stayed outside in the yard. He was also not sure which rooms in that house were occupied by soldiers and civilians. He was also not sure, confronted with the evidence from the accused, who admitted that people were actually detained in the Slash detention compound, Mohammed Ayeti conceded, of course, Salih Mustafa knows better. Regarding credibility, Your Honors, you should consider also two additional matters. First, Mohammed Ayeti's claims that he never met the accused in Slash in April are implausible. The accused himself admitted being in Slash in April 1999, and it is inconceivable that Mr. Ayeti would not be aware of the presence of his BIA commander, whom he deeply admired. Second, Mohammed Ayeti has strong ties to the accused, as evidenced by his Facebook posts and phone data record recovered from the accused's phone. He has also similarly strong bond with BIA member and former comrade Brahim Mehmetai, as evidenced by various Facebook posts. In his testimony, Mr. Ayeti had a strong motive, both to exculpate himself and to protect the accused and Mr. Mehmetai. Your Honors, some other witnesses were asked by the defense about their knowledge of the detainees at the Slash detention compound in April 1999. They all denied having such knowledge, but as was established in court, they do not possess a sufficient basis to testify as to the presence or non-presence of the detained persons there. Fatmir Sopi testified that during the period in question, he was continuously on the move, was engaged in fighting, and did not think he was there in April 1999. Seidi Veseli never visited the compound, and no one ever relayed to him any information about that place. Fatmir Humoli. This witness never visited any locations within the Slash detention compound other than the one where the wounded were staying. When he met his family there in April 1999, they were staying outside in the yard, and the witness did not enter any buildings. Teuta Hadri, a doctor, arrived in Slash towards the end of the indictment period on the 16th of April and remained there for 3 days. She was unfamiliar with the area as she had never been there before. While in Slash, she was extremely busy with her medical work. She stayed mainly in her assigned room, rarely got out in the yard, and did not visit any other buildings at the Slash detention compound. She indicated that she could only see the nearby area of the compound from the inside of her room. Ibadete Tsanoli Katsiu. This witness, a BIA member, arrived in Slash on the 16th of April 1999, where she stayed until the 21st of April. She had not been there before. Due to the passage of time, she was not able to provide the description of the place where she stayed. when shown photographs of the buildings within the Slash detention compound, she said that she did not remember whether she had seen them. Mrs. Katsiou stayed mostly inside and did not move much in the yard. She left her room only once to fetch some food from the nearby kitchen. The witness did not visit any other buildings within the compound. While in Slash, she had a great deal of medical work, and her focus was mainly on the wounded. In sum, Your Honors, the witnesses called by the defense create no doubt whatsoever about what happened in Slash in April 1999. They do not undermine in any way the overwhelming evidence establishing that the victims were brought to Slash, were detained and abused there, and that one of the victims was, in fact, murdered. Your Honors can consider why the defense has taken this extreme position of claiming that there were no detentions in Slash and that the victims are all fabricating their accounts. Why continue to insist on this defense in the face of all the evidence? Why? The answer to this question, Your Honors, is very simple. Given Salih Mustafa's role at Slash, his command over BIA and over the compound, proof that detainees were held and abused at the compound, all this establishes that the accused was responsible for the crimes committed there. He was there, he was in command, he was the only one in command of the BIA unit. He is responsible for the prisoners held and abused there. Your Honors, we are approaching, as I can see, 1 o'clock. Is this the convenient moment for us to break for lunch?
Mr. Prosecutor, I leave that to you in the sense that if you think that this is a natural moment in your presentation, then we can break for lunch.
Your Honors, I believe it's a natural and very convenient moment for us to have a break now.
Okay, very well. Then we will adjourn for 1.5 hours, so till 2:30. I wish you a good lunch, and the hearing is adjourned.
All rise. All rise.
Please be seated. I will call the appearances. I see that the SPO is in the same composition.
Yes, we're on the same composition apart from our 2 interns who have left for this session.
Okay, very well. Thank you for that. Victims' Counsel, yes, and I see the same composition for the Defense Counsel, and I also see that Mr. Mustafa is present via the video Zoom connection. Very well. We continue. I will give the floor to the Specialist Prosecution Office. It's for you now.
Good afternoon, Your Honors. Before I start, I would like to inform the panel that we plan on finishing with our closing arguments within this session. We are fairly confident that we will finish before 4 p.m.
Okay, very well. However, in that case, we will not continue today with your closing statement, Victims' Counsel, because we took note from we took note that you wanted to have at least an hour in order to compare with what was said by the Specialist Prosecution's Office, and I think that 4 o'clock is a good moment to finish, and tomorrow there will be a new day. So, okay, yeah. Mr. Prosecutor, you have the floor.
Your Honors, I will now address count 4, and specifically the evidence underpinning the charge of murder. There are no eyewitnesses to confirm the exact circumstances of the victim's final moments. Nevertheless, the evidence in this case proves beyond reasonable doubt that the victim was murdered and that the accused is criminally responsible for his murder. Your Honors, the rules of procedure and evidence allow you to convict on circumstantial evidence when the guilt of the accused is the only reasonable inference that you can draw from that evidence. The consistency and intrinsic coherence of such evidence is an important consideration in this regard. We submit, Your Honors, that even without direct evidence of the very final moments of the victim's life, every piece of evidence in this case points to one conclusion and one conclusion only, that the victim was murdered and that Salih Mustafa is responsible for it. Firstly, Your Honors, consider the exceptional severity of the mistreatment of the victim by the subordinate of the accused. This mistreatment included beatings with metal rods and the use of knives. This treatment was, from the very beginning and throughout his detention, harsher than that reserved to the other detainees. Second, the fact that the victim was not freed by the accused and his subordinates when the other detainees were suddenly released on or about the 18th of April 1999, at a time when BIA was preparing to evacuate the / detention compound. As I will explain in a moment, this is a crucial factor in the assessment of the evidence of murder. Third, consider the victim's near-death condition and his inability to move towards the end of his detention when W04669 last saw him at the / detention compound. Fourth, consider the extremely close proximity to the / detention compound. We're talking about 100 to 200 meters of the place where the victim's body was found in early July 1999. Fifth, Your Honors, consider the presence of a second body in that grave. This circumstance acquires particular relevance for 2 reasons. First, there was another detainee held at the / detention compound, whom the witnesses in this case remember with the nickname Burmak. He also was not released, together with the murder victim, when all the other detainees were freed. Secondly, this person, Burmak, was, according to other witnesses in this case, for instance, W03593, the detainee who was mistreated the most, together with the murder victim. So here we have, Your Honors, the two detainees who received the worst treatment are those who are not allowed to leave when all the others are. Finally, Your Honors, consider the state of the victim's body as found by his relatives, which is wholly consistent with the evidence of the beatings he received and with the description of the victim's condition the day the others were released. This evidence, Your Honors, is both consistent and internally coherent. As we add every piece of this evidence together, we get an evidentiary picture that only allows for one conclusion, that the murder victim was killed shortly after the other detainees were all released. We may not know the precise moment when that happened, but it was at a moment when his fellow detainees were no longer there to witness his murder. This circumstance should not prevent Your Honors from finding that the victim was murdered at the hands of the accused and his men. I ask Your Honors to give careful consideration to the decision not to release the victim with the other detainees and to the timing of this decision. This detail is extremely significant and telling of the intentions of the accused and of the other JC members with regard to the murder victim. There was no plausible reason for Salih Mustafa and his men to delay his release. There is no indication, absolutely nothing that would justify that choice other than a decision to kill him. In this regard, it is important to remember why the detainees were released in the first place. It was a decision dictated by a change in circumstances. The KLA in Slash, including the BIA at the Slash detention compound, had to leave and evacuate the civilians in the area because of the approaching Serb offensive. Under those circumstances, why were the murder victim and Burmak held back and not allowed to leave to safety with the other prisoners? Why, Your Honors? There is only one reasonable explanation, and that is that it had been decided that they would be killed, which is exactly consistent with what happened, with the severity of the beatings they received, and with the recovery of the victim's body 100 to 200 meters from the compound, together with another body. The defense, Your Honor, attempted to sow doubt on the accused's responsibility for the murder, indicating the possibility that the victim was killed by Serb forces. This is not only inconsistent with all the evidence we've just discussed, it is also a conclusion not supported by the evidence. There is in fact no evidence that Serbian forces entered the Slash detention compound and killed civilians there. There is, on the contrary, no doubt that at the time the prisoners were released from the compound, they neither encountered nor saw any Serb forces around it. In fact, upon their release, they safely walked their way back to Pristina and to other locations. Your Honors, as I said, we do not have a witness for what happened in the last moment of the victim's life. His murderers made sure of that. However, under the circumstances I have just discussed, there can be no doubt that the victim was murdered by his captors at the Slash detention compound. I will now further illustrate why Salih Mustafa is criminally responsible for this murder. Your Honors, the SPO charged the accused under multiple modes of liability, as it is allowed to do, for the crimes charged under counts 1 to 4. We have amply addressed his responsibility in relation to each count in the final trial brief. Today, we will only make some further remarks with respect to Salih Mustafa's responsibility for the crime of murder, as charged in count 4, and pursuant to the modes of liability of joint criminal enterprise, aiding and abetting, and superior responsibility. Your Honors, Salih Mustafa is responsible for murder as a war crime through his participation in a joint criminal enterprise. The SPO is explained in paragraphs 311 to 329 of the final trial brief, how the crimes under counts 1 to 4 were committed by Salih Mustafa together with a plurality of persons who included members of the BI unit under his command. We have explained how this common criminal plan included murder. Several facts and circumstances prove that the accused and the other JC members all shared the intent to commit this crime. First, Your Honors, the use of potentially lethal instruments, such as metal rods and knives, during the beatings. Second, the severity and frequency of these beatings, which reduced the murder victim to a state described by his fellow detainees as a massacre, near death, a state in which he could no longer move. Third, the accused's conduct with other detainees, such as his use of a gun during the interrogation of WO3593, and his order to his subordinates to finish victim WO1679. Fourth, and crucially, the decision not to release the murder victim. As explained, there is no other reasonable explanation why, with the self-offensive approaching, Salih Mustafa and his men would have delayed the victim's release. Finally, Your Honors, the intent of Salih Mustafa to murder the victim is evidenced by his ultimate command and control over the / detention compound and the BIA soldiers who were stationed there. Such authority and the fact that the members of BIA followed the orders and direction of the accused was amply proven at trial. Only the accused could order or approve the singling out of the victim for particularly abusive treatment during his entire stay at the / detention compound. Only the accused could take the decision not to release the victim while the others were released. In this regard, as the specialist prosecutor has already stated this morning, the evidence shows that the accused was at the compound when the prisoners were released and the murder victim was held back. Defense witness Teuta Hadri clearly indicated that she saw him one night before the Serbian offensive and on the day of the offensive on 18 April 1999. In addition to possessing the intent required for murder, Your Honors, Salih Mustafa significantly contributed to the execution of the common plan, which included murder. He did so in a variety of ways, as explained in paragraph 325 to 327 of the final trial brief. As the commander of the / detention compound, he kept the victim in detention under harsh conditions, subjecting him to a brutal treatment that had, day after day, devastating effect on his health. In spite of this, and of the visible effects that the mistreatment had on the victim, Salih Mustafa did at no point put an end to it. He at no point provided any type of medical care to the victim. On the contrary, he allowed the abuses to continue unabated until the victim could no longer move, as described in paragraph 90 of the final trial brief. Your Honors, as I've just stated, our position is that Salih Mustafa was at the / detention compound when the murder victim was killed. But even in the event that Your Honors should not be satisfied with this circumstance, in light of the evidence I've just discussed, that would not be an impediment to finding him guilty of murder. For responsibility under JCE to arise, the accused's physical presence at the time of the crime's commission is not required. In fact, under joint criminal enterprise, an accused can be held responsible for the crimes committed by other physical perpetrators, whether or not they were also JC members, provided that the crimes form part of the common criminal plan. For these reasons, Your Honors, we submit that the evidence proved beyond reasonable doubt Salih Mustafa's responsibility under the first type of joint criminal enterprise for all counts, including murder. Now, Your Honors, as we have charged in the indictment, in the alternative, and at the very least, Salih Mustafa is responsible for murder as a war crime under count 4 through the third form of joint criminal enterprise. We have described extensively in our final brief and during today's submissions the brutal treatment reserved to the victim by members of the BA unit. We have heard evidence from multiple witnesses that the devastating effects on the victim's wealth were obvious to anyone who saw him. We heard how his health worsened, beating after beating, until he could no longer move and had to be laid down on the ground by his jailers. Salih Mustafa, Your Honors, encouraged his subordinates to commit acts of violence against the detainees, even encouraging his subordinates to finish WO 1679. Under these circumstances, it was clearly and plainly foreseeable to Salih Mustafa that the crime of murder could result as a consequence of the arbitrary detention, cruel treatment, and torture of the victim. In spite of this, Salih Mustafa did not stop the mistreatments, did not stop the detention, continued to allow these crimes to take place, and by so doing, he willingly took the risk that the victim would be murdered. Your Honor, the prosecution has also alternatively pleaded that the accused is responsible as an aider and abettor. We have explained the reasons in our final trial brief. To sum up, Your Honors, his personal participation, as just described, with regard to joint criminal enterprise, I don't want to repeat myself and take more the court's time than it is necessary, also amounts to encouragement, assistance, and moral support to the acts of the physical perpetrators. For instance, by allowing the premises of the slash detention compound to be used as a place of illegal detention and mistreatment, the accused provided practical assistance to the commission of these crimes, including to the crime of murder. This practical assistance, Your Honor, had a substantial effect on the commission of the crimes. Now, as the commander with the ultimate authority over BIA and the slash detention compound, and with knowledge of the crimes being committed there, Salih Mustafa was necessarily aware that his conduct would contribute to the commission of these crimes, including the crime of murder. Lastly, Your Honor, I will address his responsibility for murder under the doctrine of superior responsibility. Your Honors, the accused is criminally responsible for the crime of murder also because, as a superior, with the requisite knowledge, he failed to prevent and punish the murder committed by his subordinates. This was a double failure, Your Honor, because he knew the crimes were about to be committed and failed to prevent them, and he knew the crimes had been committed and failed to investigate and punish them. The physical perpetrators of this crime of murder, but also of the other crimes, were all members of BIA, of which the accused was the commander both de jure and de facto. The accused's effective control over his subordinates is evidenced by a plethora of factors, which we have discussed in detail in our final brief. They include his ability to impart orders and discipline his subordinates. The accused himself explained extensively in his interview the high degree of control he was able to exercise over the members of BIA. The accused had knowledge, or at the very least he had reason to know, Your Honors, that his subordinates were about to commit crimes against those detained at the slash detention compound, including the murder victim. This is established by the very factors we have listed with regard to his intent under joint criminal enterprise, and especially the brutal beatings he was routinely subject to, including with metal rods and knives. Also, the accused was at the slash detention compound the day that the murder victim was brought there. The accused also knew or had reason to know that the victim had been killed. First, he knew that the victim had been detained at the compound. Second, the fact that the victim had died was known within the local members of the KLA at the latest 1 week after his death. W04600, in fact, testified that he learned about the victim's death on 23 or 24 April 1999. That is less than a week after the release of the other detainees. It would be unreasonable to think, Your Honors, that the commander in charge of the place where the victim was detained would not be aware or have reason to know of this very fact. In spite of this knowledge, whether actual or constructive, and despite his effective control over his subordinates, the accused failed to take necessary and reasonable measures to prevent and punish the crimes of his subordinates, including the crime of murder. In fact, Your Honors, he failed to take any measure at all. In conclusion, Your Honor, the guilt of the accused for under count 5, the accused is guilty of murder under count 4 of the indictment under joint criminal enterprise, aiding and abetting, and superior responsibility. Your Honors, this concludes my part. I will now give the floor to Prosecutor Michalczuk, who will address the issue of sentencing.
Very well, thank you. Mr. Prosecutor, you have the floor.
Your Honors, the final part of the SPO submissions today concerns sentencing matters. This morning, the Specialist Prosecutor addressed the SPO's request for a lengthy term of imprisonment in light of the circumstances in this case. The term of imprisonment should reflect the following factors: the gravity of the crimes committed by the accused, their severe consequences on the victims, the role of the accused in the crimes, the presence of multiple aggravating factors and the lack of mitigating factors, as well as the importance of general deterrence in cases like this one. Your Honors had some specific questions regarding the sentencing scheme that we addressed in our filing F00471 dated 8th of September, and we will not cover those matters any further now unless, of course, Your Honors have any further questions. Part 6A of the Prosecution Final Trial Brief discusses the applicable sentencing ranges before the specialist chambers, which is a maximum term of life imprisonment. For the purpose of those closing statements of today, I will focus mostly on 4 distinctive issues: the gravity of the crimes committed by the accused, the role of the accused in the crimes, including his direct participation, the presence of multiple aggravating factors, and finally, the absence of mitigating factors. Let me discuss, Your Honors, first the issue of the gravity of the crimes committed by the accused. Your Honors, pursuant to Article 44, Paragraph 5 of the law on the specialist chambers, the gravity of the crimes and their consequences are relevant factors in guiding the imposition of punishment by the panel. As discussed in the prosecution final trial brief, there is no doubt about the fact that the crimes proven in this case are not only grave, but also utterly brutal, as are the consequences of these crimes on the victims. Your Honors will remember the words used by the victims when describing the beatings, mistreatments, and torture they underwent. Victim 1679 testified in this court about the way he felt when he and other detainees were continuously and daily abused by their captors.
Today, tomorrow, you were waiting for you to be killed.
This witness, Your Honors, explained that from the cowshed, he and other detainees could hear when people were beaten up in the upstairs building. He said,
your sound, what you have been saying, the sound of the video was off. But the video, no, I don't understand.
The audio
Yes.
not on for the courtroom and for the recording.
Okay.
The prosecutor wants to replay the beginning.
Okay. Would you like to replay the video?
Yes, Your Honors. Yes, Your Honors. With your permission, we'll play the video again.
We could hear people screaming, and we could hear hard sounds, and we simply couldn't sleep because we were scared that at any time they would come down and bring us upstairs as well.
Mr. Prosecutor, at least for me, it was not possible to hear what was said. I don't have audio at the moment. No, I had my headphones on and I didn't hear. Mr. Prosecutor, if you would not mind, could you repeat it again? I think there was something. There was a problem with my audio.
Right, right. Your Honors, we'll play this clip again.
Okay, thank you.
You were just waiting for death when it will come. Today, tomorrow. You were waiting for you to be killed.
This witness explained that from the cowshed, he and other detainees could hear when people were beaten up in the upstairs building. He said, we could hear, I could hear all sorts of voices. And it's there where I learned that somebody's voice can change because of what he's undergoing. You could hear people screaming, howling like dogs, making sounds like cats, screaming cats, because of the torture and pain. When asked to describe his mistreatment and its consequences, another victim, victim 3593, said the following, Your Honors, and we will play another clip with the testimony of this witness.
I can tell you that I fainted a couple of times, 2-3 times I fainted. I was hit with wood, I was kicked, I was hit in different ways. I was hit, I don't know what with, so my finger was broken, my teeth were broken.
This victim described also how terrified he and other detainees were, sitting in their barn while others were mistreated outside. And we will, Your Honors, play another clip from the testimony of this same witness.
We could hear people screaming, and we could hear hard sounds, and we simply couldn't sleep because we were scared that at any time they would come down and bring us upstairs as well.
The detainees were also witnesses to the brutality of the mistreatment and torture inflicted on the victim who was later murdered. Witness 1679 testified that the murder victim, and I quote, was one of the persons who was beaten the most, injured the most. He was brutally mistreated. Again, in the words of this witness, and I quote again, it was a catastrophe. His body had all these marks. It was terrible. Every one of us was beaten, but he was beaten the most and he was massacred. According to witness 4669, the murder victim was black from the beatings. He said everything on his face, his eyes, his nose, everything was black. He was bruised, black on all visible parts of his body. He could barely open his eyes. Let me play, Your Honors, a very short clip of the testimony of this witness, in which he described the dire condition of the murdered victim and the abuse he was subjected to by his tormentors.
Yes, he was brought once more, and we did not see him after that. When he was brought the second time, he was almost dead. He was lying down, crying out of pain. He was even more swollen. His nose was bleeding. So, in other words, he was unable to speak. He was just crying out of pain. This happened on the second time. In order to explain it to you, we heard him when they brought him the first time, then they brought him outside. I don't know if they brought him outside the first or the second time, but when they brought him the second time, they took him outside. They beat him heavily then, and we could see from the openings that he was being beaten by 5 or 6 persons.
The beatings that were inflicted were unpredictable and extraordinarily violent. At times, the victims were beaten so severely that they fell unconscious. The tools used to administrate beatings and mistreatments included candles in order to inflict burnings, electricity boxes in order to inflict electroshocks, wooden sticks and iron rods to inflict heavy beatings. The torture with the electricity box was usually done by 2 subordinates of Salih Mustafa, with him Cherimi, also known as Dardan, and by another via member by the name of Afrim. Your Honors, we discussed already at the beginning of these closing statements the deplorable, inhumane conditions of detentions. And remember, Your Honors, what witness 3594 said. He said the following thing: I felt as if I were an animal and no longer a human being. The circumstances of the victim's detention and mistreatment were also extremely humiliating and isolating. Several of the victims sought to join the Kosovo Liberation Army or support its cause, but were targeted by the accused and his subordinates and labeled as collaborators or spies without any basis or possibility to defend themselves or refute those baseless accusations. Those words, spy, collaborator, thief, liar, were chosen by the accused and his subordinates because of their powerful meaning at that time in the context of the war in Kosovo, and also still nowadays in current Kosovo society. By choosing those words, by using those words, the accused and his subordinates wanted to label, to marginalize the victims, to separate them from their families and communities. Branded as collaborators, the victims were deemed enemies of the KLA and pariahs in their communities. Those designations isolated the victims both during their detentions and long afterwards. Even after their release, the victims had to hide in shame what had happened to them and were forced to live as survivors without any community or support. The consequences of those crimes were far-reaching, both psychologically and physically, for the victims, but not only for them, they were also for their families. Without going into the details of these consequences, which are confidential because of their very nature, I would just refer your honors to part 6, paragraphs 361 to 364 of the prosecution final trial brief. I will turn now, your honors, to the specific role of the accused in the commission of the crimes. In this case, the accused both directed the crimes and he participated in them. He was the BIA commander and was in charge of what was happening at the Slash detention compound. At the same time, he also was a participant to the crimes perpetrated there, and his sentence, your honors, should reflect his dual role. The accused ordered his subordinates to detain and abuse the victims, resulting in the death of at least one of them. He mistreated the victims himself, using his own hands and weapons to abuse them. He interrogated and beat victim 3593 in the presence of his subordinates, modeling in this way for his subordinates the type of conduct that he desired. After 3593 was beaten, the accused placed a revolver against the middle of his forehead and pulled the trigger. This behavior displayed for his subordinates an utter disregard for human life and dignity, a desire to instill terror, and a readiness to kill. On several occasions, the accused witnessed the mistreatment of victims and encouraged his subordinates to continue. After initiating the beating of victim 1679, the accused commanded his subordinates to finish him. The sentence that your honors will decide upon needs to be severe to reflect the specific role that the accused had. A leader who abused his role. A leader who directly participated in the crimes to help ensure that his order as commander would be fully carried out by his subordinates and be fully carried out with brutality and disregard for human dignity. I will now move to discuss aggravating factors and also the mitigating factors. Pursuant to Article 44, Paragraph 5 and Rule 163, Paragraph 1, in determining the accused's sentence, the panel shall consider as appropriate aggravating and also mitigating circumstances where applicable. The trial panel has a wide discretion in determining these circumstances and the weight to be accorded thereto. With regard to aggravating factors first. The prosecution hereby invites the trial panel to consider at least 3 aggravating circumstances. 1, abuse of power, official capacity by the accused. The fact that the crimes were perpetrated on particularly vulnerable or defenseless victims. And 3, the fact that the crimes were committed with particular cruelty. Let me discuss these factors one by one. Abuse of power. The accused occupied a significant position within the Kosovo Liberation Army. He was a commander, and he exercised a significant leadership role in his unit, BIA. But he abused his position, he abused his power as the commander of that unit. His superior position and his role in the beatings and torture at the / detention compound, together with his continued approval and endorsement of the same acts during the indictment period, should be considered a highly aggravating circumstance. Let me now discuss the issue of vulnerability of victims. As discussed earlier today, the victims of the accused and his crimes were particularly vulnerable and defenseless, and rendered even more vulnerable as a result of the crimes and because of the isolation and remoteness of the / detention compound. This position of special vulnerability is evident when the victims are in a situation of illegal detention without access to any contact outside of the place of their detention. And in this case, the victims were individuals who were arbitrarily detained, who were kept in inhumane and humiliating conditions, in complete isolation from the outside world, and without any possibility to make any contact. The victims of the accused were vulnerable, defenseless, and they were at the mercy of their captors. They routinely witnessed the beatings endured by one another, which created an atmosphere of terror and shock that contributed to the victims' general state of fear. The degree of suffering and humiliation inflicted, the degrading conditions of detention, and the loss of dignity are all factors that aggravate the crimes committed by the accused. The victims of the accused were also labeled as collaborators, and in this way were even further prevented from seeking justice, even after they were released. As a result, the crimes committed against the victims had long-lasting consequences, both physical and psychological, which are circumstances that aggravate further the crimes committed by the accused. Finally, with regard to cruelty, in evaluating the manner in which the crimes were perpetrated, Your Honors should take into account the level of brutality, barbarity, and zeal of both the accused and his subordinates under his command. The brutality of the crimes has been discussed already earlier and is evidenced by both the tools or means of perpetration and the level of suffering inflicted upon the victims. Just as an example, Your Honors, the use of hot irons or bars and electrocution speaks to the brutality of the mistreatment and torture. Similarly, the firing of a gun against the forehead of 3593 denotes deliberate cruelty. The SPO invites Your Honors to take into consideration all of these circumstances, at a minimum as aggravating factors. I will be brief on mitigating factors, as there are simply no circumstances which could mitigate the sentence to be imposed on the accused. In particular, the accused expressed no remorse or indication of sympathy, compassion, or sorrow for the victims. Regardless of whether he declared himself innocent or guilty, never once did he address, if nothing else, at least out of respect, the victims in this case. The victims who were Kosovo Albanian civilians who suffered severe crimes committed by fellow Kosovars. The accused offered no condolences for the harm suffered by the victims and their families, and never acknowledged the pain and suffering that the victims in this case have endured. Further, any possible submissions as to the good character of the accused or lack of his prior criminal convictions should not be given any substantial weight and should in no way detract from the crimes the accused is charged with, given the gravity of the crimes he has committed. All of these aggravating factors are highly relevant to Your Honour's determination on sentence. The crimes committed by the accused are particularly grave. His conduct was particularly serious and had devastating consequences on the victims and their families. If victims and witnesses are meaningful actors in trials like this one, where the mandate of the court is to try crimes that include very serious ones like war crimes, then victims and witnesses deserve that such crimes be adequately punished. Your Honours can do that by imposing the sentences required by the SPO, which are fully warranted in the specific circumstances of this case. For all these reasons, and based on the entirety of the evidence adduced at trial, the SPO hereby requests the panel to impose the following sentences on the accused. Count 1, arbitrary detention, 10 years imprisonment. Count 2, cruel treatment, 20 years imprisonment. Count 3, torture, 25 years imprisonment. Count 4, murder, 33 years imprisonment. Rule 163, paragraph 4, requires the panel to impose a single sentence reflecting the totality of the criminal conduct of the accused. It remains open to the panel to sentence the accused to the terms of imprisonment set out in relation to counts 1 to 4 cumulatively, or to a higher sentence of imprisonment than that set out in relation to any specific count. In order to reflect the totality of the criminal conduct of the accused, the SPO requests to impose on the accused a single sentence of 35 years imprisonment. Thank you.
Thank you, Mr. Prosecutor. With this, we conclude for now the closing statements of the Specialist Prosecutor's Office. Tomorrow we will continue with the agenda as already discussed with you. I repeat, we will have tomorrow the closing statements of the Victims' Counsel, both on guilt and innocence of the accused and the sentencing for 1 hour, we noted. And we will also have the closing statement of the defense on the same subjects for 4.5 hours. Yes, Mr. Van Bonnet? Yeah. Very well. Then we have reached the end of our session. If there's nothing else that parties and a Victims' Counsel would like to raise, I am doing the tour. Mr. Van Bonnet, is there something you would like to raise? No, very well. Thank you. Then we will adjourn the hearing, but not before I thank the parties and the Victims' Council for their attendance, and I thank the interpreters for today's assistant and the audiovisual technicians and the security and our stenographer. Yeah. The hearing is adjourned.
All rise.